Friends, colleagues, welcome to Ulster University. My name is Rory O'Connell, formerly Director of the Transitional Justice Institute, and since then wearing various other hats I can't quite remember. But it's a real pleasure to welcome you to this event with the Transitional Justice Institute, our friends and colleagues from the Equality Coalition, and an event supported by the Gender, Justice and Security Hub, which is one of the Global Challenges Research Fund UKRI research hubs, so meant to be one of the flagship research endeavours in the United Kingdom. To say a little bit about the topic today and those institutions, we're going to be discussing how could minority and women's rights be protected in a united Ireland. And this discussion about a united Ireland or a border poll is something that was, of course, brought much more into public consciousness by the events of the Brexit referendum in 2016. Prior to then, academics like myself didn't pay too much attention, to be honest, to issues about reunification or unification. But since the vote in June 2016, almost immediately became obvious this was something we have to think about, if for no other reason than because, as we discovered with the Brexit referendum, you can have referendums and be surprised by the result. And we can't afford to be surprised by the result of a unification referendum. So TJI has been one of the leading institutions academically looking at some of these issues. We were one of the first to have a public event on unification referendum and referendums more generally. It was our last public event before lockdown, as it happens, in 2020. And our work in TJI has been distinctive in that we have brought to the fore issues around equality and participation in particular in these debates about border poll and unification. So that's TJI. Very pleased to be working with the Equality Coalition, which is co-convened by the Committee on the Administration of Justice, and I'll hand you over to the Director, Daniel Holder, in a minute, and Unison, led by Patricia McKeown, who will be joining us for the second panel. And TJI and the Equality Coalition, or more precisely the Committee on the Administration of Justice, along with colleagues from Queen's University Belfast, are part of a big project, this Gender, Justice and Security Research Hub, with more than 40 different projects across the globe, everywhere from Afghanistan to Colombia, from Sri Lanka to Sierra Leone. And we're really delighted that the hub can support this endeavour. One of the research questions of the hub that was highlighted to us at a hub event a few months ago was, what does a radically transformed future look like? And of course, a united Ireland would well be, or could well be, a radically transformed future. So it's in that spirit that we brought together two wonderful panels of experts and people who have been contributing to these public debates over many years to look at the issues about minority rights and specifically women's rights. And I'm really looking forward to hearing what all of our speakers today have to say and to the discussion to follow. So Daniel, over to you.
Thanks very much. Thanks very much, Rory. It's good to be here. So, in terms of the Equality Coalition, for those not familiar, Equality Coalition is a network of over 100 trade unions and equality NGOs that is co-convened by my own organisation, CAJ, and the trade union Unison. We've worked across a range of equality issues for the last sort of 25, 30 years. Whilst we might not have used the phrase constitutional conversations much often before, when you actually look back at a lot of things we have been doing, there's been quite a lot of that. Most of it, of course, is actually focused on reforming Northern Ireland within the UK. We've focused on a lot of things that are outstanding from the peace agreements, the implementation of a Bill of Rights, and indeed the sort of rights-based safeguards that were committed to as a part of the peace settlement that haven't really been implemented. In fact, this seminar, of course, is the second in a series. I'm sure we'll have more. But the first one, which was last month, we actually looked at that question again. We actually looked at the question of, I think the title was, could rights-based safeguards save Stormont, if it is ever actually there? And we looked at the sort of framework that was supposed to be in place vis-a-vis what it actually happened. This is the first seminar we've actually held that is focusing specifically on the question of the constitutional framework within a United Ireland and how that could afford rights protections. I'm being told to move slightly over here, so I'm actually on camera. We did have a seminar, for an internal seminar actually in April, but it was too risky to hold it in public, of Equality Coalition members just to talk about the current state basically of what you could call freedom of speech on practically any issues, the amounts of groups within our sector who are still facing levels of intimidation and attacks, either for work on constitutional change but also for work on various other things, be it Brexit, be it feminist groups, be it other member organisations of the coalition, Irish speakers, others. So we did have that discussion, and we reflected on the framework of the Good Friday Agreement that had affirmed a number of rights. Right to free political thought, right to pursue democratic national political aspirations, right to seek constitutional change by peaceful and legitimate means, the right to women to full and equal political participation, and how that context hadn't really been realised in light of the current climate. What we're at today, though, is we're looking at this question of trying to look at what the blueprint for a new constitutional framework would look like to avoid that type of Brexit situation where there's a referendum without a blueprint, but also to avoid these conversations that are happening, but where there are significant gaps about the issues around rights protection. And who knows, we could be by next year into a more official Scottish-style process of planning a constitutional framework. But how loud will the issues of rights protection be heard within that discussion? And in fact, unless I've completely missed something, I think a number of the issues that are on the panel today haven't had a huge airing. Specific issues around minority rights, for example, which is the subject of the first panel. So just to tee up the first panel, by minority rights, what we mean is what's written into international human rights law. So we're talking about ethnic, religious and linguistic minorities. We're talking about the United Nations 1992 Declaration on the Rights of National, Ethnic, Religious and Linguistic Minorities as a framework. But we're actually also talking about two Council of Europe treaties that are very specific to the Good Friday Agreement. So as a result of the Good Friday Agreement, the Irish government signed up to the Framework Convention for National Minorities, which covers linguistic minorities, also ethnic minorities. Part of the rationale around that was the position of unionists in a future United Ireland. The UK government, under the Good Friday Agreement, signed up to the Council of Europe European Charter for Regional Minority Languages to afford a level of protection for the Irish language and also for Scots in Scotland and Ulster Scots here, as well as Welsh, Scots Gaelic, Cornish, etc. Colin will chair and introduce. Colin Harvey will. There's two Colins. Will chair and introduce the panel. One panel member who isn't here, unfortunately, is Dr. Selima Mwanga from Adikwa, the Migrant Women's Network Ireland. Unfortunately, just due to personal circumstances, she couldn't travel up today. But we will try and get her contribution to this because it will be an important contribution to the debate. The panel will cover all of those elements of minority rights. In terms of linguistic minorities, we have questions around, well, there would be no European charter in a future United Ireland because Irish is an official language. The charter doesn't cover official languages. The rights deficits for Irish speakers in this particular jurisdiction are extremely profound. What type of framework would be needed to ensure the rights commitments are actually realised? What would happen to the Irish Language Commissioner, that type of model, the model that's been set up through the eventual Irish language legislation, assuming a post holder is actually ever appointed? And also what would happen to Scots, in terms of the Ulster variant of Scots. The UK has recently moved as part of a political deal to actually view Ulster Scots more through the prism of ethnicity than through a linguistic minority. What impact would that have on or how would that, if at all, be reflected in a future constitutional framework? Then in terms of turning to ethnicity and the question of minorities in that sense, unionist as a minority in the United Ireland, what would be first of all, what would be the characteristic that would measure that? Would it be political opinion? Would it be religion in terms of protections for a Protestant minority, vis-a-vis the Protestant minority in the north with existing Protestant minority in the south? Would it be through British citizenship? That's one of the areas of the Good Friday Agreement which is expressly carries on into a United Ireland, the issue of birthrights to British or Irish citizenship, interpreted entirely differently by both governments. The Irish government saying that very much as an entitlement to be British or Irish, the British government saying that definitely and currently conferring British citizenship on everyone or almost everyone born here. Obviously, if you did that and had the entitlement model, well, you'd need a framework whereby there was equality of treatment for British and Irish citizens and things like referendums and everything. Equal rights would have to be underpinned in some sort of sense. That's part of the discussion. Then in terms of migrant communities, there's a huge range of issues now. I mean, there's we'd get rid of the evil hostile environment for a start, but the Irish system, if you think of things like direct provision, which hopefully is on the way out, is hardly a shining light of good practice. There's the issues around citizenship, but there's also very specifically the question of, well, what happens to the common travel area? There's a UK Ireland common travel area. It was put in place because of the land border and the impossibility of doing passport checks on the land border. There won't be a land border, so does that as element of the common travel area disappear? Are there passport checks between here and Britain? Are they not? What about the things that have been just recently tagged on to the common travel area around that are meant to design for British and Irish citizens full free movement, but that don't include other permanent residents on these two islands? So look, there's a lot. I'm winding myself up here with everything because there's just so much to unpack in these questions, and there's been very little discussion on it. That's what we want to kick off. Over to Colin.
Okay, thank you, Daniel, and thank you to TJI and the Equality Coalition and the Gender, Justice and Security Hub for organising the event today and for the invitation to be here. I'm Professor Colin Harvey from the School of Law at Queen's University at Belfast. Just before I start, I don't get the opportunity much, and haven't in recent years, to do this in person, so I want to do it in person today. I owe an enormous personal debt of thanks to a number of people who are in this room and a number of people who are watching online as well for taking the risk, really, of expressing solidarity and support with myself in recent years. I want to acknowledge that today personally because many people are in the room who did that. I use the word risk deliberately because I think it was a risk and I don't take it for granted, and I just want to make that clear and say that before I get underway today. This is a really, really significant event, an essential and necessary discussion. You're very welcome to the panel about protecting minority rights. To put it at its simplest, really, people here have a choice about their constitutional future. And to my mind, at least, it's unsurprising then that we're here this afternoon thinking about and reflecting on the implications of an available and entirely legitimate option. In some ways, this is an unsurprising, uncontroversial conversation. And as we know, we were all promised, and we have been promised time and time again, that we have a right to have this discussion and this conversation. But as we also know in this society, we've all been made many promises that haven't always been kept. What we're doing today is, I am a neutral, independent, impartial chair of proceedings for this panel, is to focus on the detail of the possible implications of constitutional change, including the various options, guarantees, protections and assurances, with a particular focus today on the equality and rights impact. And a number of people have been making the case essentially that it's vital that those who care about equality and rights join in and participate in this discussion. So it's really, really great to see you all today and to have people joining us online and to be here at this wonderful new space to do this. We're going to have three presentations on three themes: focus on cross-border constitutionalism after reunification, the rights of unionists in a united Ireland, and the rights of linguistic minorities, with the example of the Irish-speaking community. I'm going to ask each speaker, and I'm conscious that we've slightly overrun a bit this afternoon, to take up to 15 minutes each. If you want to take less than 15 minutes, you're very welcome to do so. 15 minutes each. I will try in various ways to indicate when we're approaching 15 minutes for each speaker. But the aim of today is to have a relaxed, informal conversation about the options that are available on the choice that is there, one possible choice. And I very much hope that this isn't a a one-off event. We're going to have more and more of these discussions, and we know that it's happening. Now, we've got a stellar panel in this panel on minority rights, and each of our amazing speakers has provided me with very, very, quite extensive bios. And if they don't mind, because through the power of Google and everything else, you're aware of how distinguished all our panels are. So I'm going to simply introduce our speakers by name and then by title of their presentation today, just conscious of time. So I'm delighted to say that our first speaker, you can't have too many Collins in any panel, right? That's a rule for the future, is Professor Colin Murray from Newcastle University, who, as many of you know, is doing outstanding, remarkable work. And the title of his presentation is More Than Geography, Cross-Border Constitutionalism After Reunification. Colin.
There's something particularly exciting about being at a panel on minority rights and it being the first panel I've ever been at where Collins are not in a minority. Thank you all very much for the opportunity to speak this afternoon. I think, as Colin has said, we have to recognize the backdrop to events like this. It's hardwired into the 1998 agreement that we all have the right to talk about the constitutional arrangements under which we're governed. And I'm really excited as a constitutional lawyer to do that, but to have a room full of people and people online who are willing to engage in that conversation more broadly is a really exciting thing. And to talk about these arrangements is empowering for people. We have a set of arrangements that people in this place have the choice to shape, and it therefore is our duty to have as detailed and informed a conversation as possible to let people make those choices. Because uninformed choices in the context of constitutional change are absolutely meaningless. As Rory said, we live in the aftermath of ill thought through constitutional conversations around the Brexit referendum in 2016. People need to understand the wide ramifications of what's happening in terms of the constitutional future of these islands, and it's impossible to do that without starting an event like today. Now, I am conscious that some of the themes that I'm talking about will touch quite heavily on the themes that Professor Dickson is raising in his paper. What I want to try to disaggregate, therefore, is some of the actual protections for minority rights that would need to develop in a space after reunification. And on the other hand, some of the procedures and structures, the institutional structures that will overarch those arrangements. I think one of the fallacies that we fall into when we talk about constitutional change and Northern Ireland and Ireland reunifying, or a change in that constitutional relationship, is that we think about it in really bald terms of statehood. And we imagine all of these ticky-tacky boxes of what it is that the nation state is in the 21st century. And that all states abide by a set of rules and that the state is central to our understanding of international relations in general. But as Dan mentioned in his introduction to this panel and this event as a whole, we're living in a world where national sovereignty is increasingly mutable and needs to be seen in a web of interconnectedness that, well, it deals with the challenges of people moving around in the world in the 21st century, in a world where environmental challenges impact globally. And an idea of national sovereignty, pure and unalloyed, isn't necessarily going to work in the context of those challenges. So when I talk about cross-border constitutionalism and this space, I want to talk about something that is already happening and how that might change in the event that there is unification of Ireland. So the first thing that this raises is, well, what might be a residual post-sovereignty role for the United Kingdom in the context of the island of Ireland? The easy answer to say is, well, the 1998 agreement envisages a shift of statehood, that the governance of Northern Ireland is transferred to Ireland and Ireland's statehood is complete in that context. But I suppose if we look at historical comparators of shifts in statehood, we maybe get examples like Hong Kong coming up in a recent past. And we get arrangements whereby there are treaties that need to cover everything from payment of public sector workers' pensions and what might seem prosaic issues but aren't to the people who are involved, through to rights issues embedded in those treaties. Now, the treaty with regard to Hong Kong was supposed to cover 50 years after the period of Hong Kong being returned to China. Now, we're halfway through that period, and the tensions that have arisen around that are perhaps clear for all to see now. But the 1998 agreement sets up a different sort of framework. It sets up a continuing set of provisions that move with statehood, a rigorous impartiality duty, and duties around people's ability to identify as British or Irish or both, that I'm sure we're going to hear an awful lot more about in some of the talks that continue through today. There is no time limit on those arrangements in the same way there is in the UK-China treaty with regard to Hong Kong. So one of the immediate results of that is that there will be a continuing co-guarantor role over those protections, much as Ireland asserts at the moment, continuing for the United Kingdom in a post-sovereignty over Northern Ireland position. I don't think we can escape that there will be some set of arrangements that need to be in place for managing that, continuing into the future. Now, the other distinct difference, and it's one to double underline at this point, is that whilst the institutional architecture, the treaty framework, might look superficially like what's gone on between the UK and China over Hong Kong, the context is profoundly different. We are talking about countries that are liberal democracies and that have embedded sets of rights arrangements and embedded sets of minority protections in terms of their international commitments that exist within this space, that are entirely divorced from the reality of Hong Kong today, and perhaps not having those safeguards has become acutely evident in some of the upheaval that exists in Hong Kong today. When we're talking about these arrangements, there is already a set of, bedrock in place that, didn't exist whenever we talk about partition in Ireland in 1922. Sovereignty as it exists in the 21st century is really very different than that context of a century ago, or perhaps other contexts in the world where liberal democracies are not involved. So on a lot of levels, we're dealing with a privileged set of arrangements or a firm set of foundations that we can build upon in relation to reunification, something that we don't have to construct from the ground up. Now, Rory and Daniel, in their introductions, mentioned the significance of the common travel area and mentioned, particularly for Daniel, that was created in 1922 to manage the difficulties of having a land border suddenly come into effect in this island. And I don't want to minimize just how significant that was, because land borders went up all across Europe that did not exist before in the aftermath of the First World War, and there were very few efforts to immediately mitigate them at that time. Ireland and the United Kingdom were able to make something work, even in the teeth of, let's face it, really quite fraught relations after the War of Independence. And a century on, we've got to see that this wasn't just about having a land border. This is about a mutual set of advantages that both polities derived at that time. The UK had an acute need for movements of labour from Ireland into its industries. Ireland perceived an acute need to be able to manage population through movements between these islands. And that source of mutual advantage was baked into the common travel area arrangements. And even though that idea of the industrial population of mill towns in Lancashire is no longer a pressing concern, the common travel area has moved past those immediate relations. I'm able to live here in Belfast today, work in Newcastle, and have family in Cork, and travel between these destinations really easily under the rubric of the common travel area. Now, the issue going ahead is, how does that fit with Ireland having a set of obligations as being a continuing EU member state? Currently, Protocol 21 and Article 3 of the protocol as amended by the Windsor Framework allow for Ireland to maintain its common travel area protections. Now, that doesn't go away in the event of reunification. There is still that bedrock in EU law for Ireland to be separated out from the general obligation on EU member states to become part of the Schengen free movement area. But that's brought disadvantages for certain groups in these islands in recent years. We heard Daniel mention direct provision with regard to Ireland. One of the repeated justifications for direct provision was the need to prevent pull factors across these islands and for Ireland not to be out of line with the protections offered to asylum seekers and refugees by comparison to the United Kingdom. That there was an acute awareness that the common travel area existed and that Ireland therefore had obligations to the United Kingdom in this context. We're moving into a scenario after the UK has ceased to be an EU member state where Ireland is probably going to look to roll back on some of the opt-outs, on common justice and security measures that the EU has put in place that Ireland opted out of because of the common travel area. Those opt-outs and the way the common travel area works are profoundly disadvantageous for groups of refugees that are scattered across these islands. There have been big movements of people from countries like Ukraine and Iran that have family across the United Kingdom and Ireland at the moment. And maybe we need to think again about how the common travel area works today to get the common travel area ready for a scenario where it might exist across polities that are divided by a sea border completely. There is no fixed reason why there could not be bilateral visa waiver arrangements covering large groups of people to make this move easier in a way that doesn't cause even more dislocation where families are spread across these borders. We're in an era where North-South bodies are not working as a result of the boycott of Northern Ireland's own domestic arrangements at the moment. But that existed as well in 2002. And in 2002, the UK and Irish government, by an exchange of notes, allowed Northern Ireland's government departments to continue to be represented in North-South bodies. If we're serious about saying that that was an important part of the post-1998 framework, why are we not talking about a similar exchange of notes today in the context of indirect rule as opposed to direct rule? Because if some of those foundations aren't put in place and maintained, it gets much more difficult to do those cross-border elements of planning that would make reunification easier, that level of alignment that helps this to work. And in a post-reunification environment, we're going to continue to see a need for exactly those sorts of bodies. We live in a small, damp archipelago in the North Atlantic. Considerations of environmental protection are not going to stop at national borders. And we need to reconsider the significance of those North-South bodies and double underline them because they're going to matter in the future. And perhaps lastly, substantively, we're going to have to think about the Windsor framework. Because at the moment, this most controversial of measures actually does allow for a level of trade movement across these borders that a lot of unionist politicians have said has been essential to their conception of unionist identity. Now, it might be entirely controversial at the moment as a development, but the boycott of Stormont hasn't stopped it coming into force. And as the Windsor framework beds in, companies here are going to rely on this set of arrangements. 10, 15 years down the line, you're not going to be able to rip these arrangements away. There is going to be a space that exists for continuing trade protections in these islands. Now, I don't want to overemphasize the British-Irish nature of this set of relations. Unionists will not be the only minority group that are affected by reunification. And in a lot of ways, they're a large, geographically contiguous and homogenous group that will be able to exert an awful lot of weight within a democratic polity like Ireland. We've seen in the last 100 years populations like travellers drop off a cliff in terms of population numbers in Northern Ireland by comparison to Ireland. And we need to perhaps think about what reunification would involve acutely in terms of minority rights across the board. And I suppose one of my takeaways from this is that that is not something that advantages one group. That when we talk about minority rights, we need to talk about this generally, and that there is not a loudest voice in the room scenario to the removal of all else. Thank you so much for your time.
Thank you very much, Colin. Excellent, and really into our next speaker perfectly, really in terms of the theme. I'm delighted to say our next speaker is Professor Brice Dickson from Queen's University, Belfast. And I'm not, I think, giving away any age-related secrets, but I think you were contributing to these discussions for the New Ireland Forum back in the mid-1980s, Brice. So Brice has been at this for a while. So Brice is going to talk about how to protect unionist rights in United Ireland. Absolutely vital discussion. Thank you, Brice.
I can't really stand here. Is it okay if I sit here? Can I be on camera and sit? Does that go up higher? Or maybe you have to be sitting on it to go higher.
No, if you want to go up here, get on to it first. That's actually the highest, okay.
Okay, is that okay with the cameras?
Sean, cameras will work here?
Hi everyone, and thanks to the organisers, thanks to Colin for the introduction. First and foremost, I need to assert rather strongly that although I'm talking about the protection of unionists in a possible united Ireland, I am not myself a unionist. And Colin's right, back in the early 80s I made a submission to the New Ireland Forum and the Forum for Peace and Reconciliation in Ireland, talking about, as an academic lawyer, the perspective of unionists in a reformed Ireland. But I was doing that purely as an academic, not as a unionist. And even though people like Brendan O'Leary in his latest book, Making Sense of a United Ireland, describes me as a liberal unionist, and I'm quite happy with the term liberal, I'm not happy with the term unionist. I don't quite think I can sue for defamation for that claim yet, because they still have some kind of reputation, unionists. But anyway, I just wanted to get that clear. I'm not speaking as a unionist, nor as a nationalist. I openly admit to be a proud member of the Alliance Party and to be one of those people who will decide when the time comes which way I want to vote. And that really takes me to the first of my points. What I'm going to say is really reflected in the 4 bullet points that were on the programme for today. The first point is that the rights of unionists, the rights of anybody in a united Ireland, or anybody living in the north at the moment in a united Ireland, depends very much on what kind of united Ireland we vote for, as previous speakers have mentioned. And the biggest possible factor in that, the main change that might affect things is whether we keep the Assembly and the executive institutions under the Good Friday Agreement in a united Ireland. To some of you, that it might seem very odd that we would do that, but actually that is the default position at the moment. Under public international law, unless the Good Friday Agreement, the British-Irish Treaty, bit of it at least, is denounced by one of the parties, then it remains in force, even after a referendum for a united Ireland. Now, most of us assume that with a referendum, with a vote for a united Ireland, there would, if not at the time, then shortly thereafter, be a treaty between the UK and Ireland, telling us what a united Ireland will really look like, and in particular what will happen to the Assembly and the Executive. My own current position, I think, is that it would be no bad thing if the Assembly and the Executive were to remain in place, at least for a time, after unification. Why? Because it would lessen the suddenness of the rupture, so to speak, and probably, if you were a unionist, give yourself some reassurance that life is not going to change overnight, and that for a while your political representatives in the 6 counties will continue to have some say over this place, over how this place is governed. And then through time, the institutions here can melt away and a properly integrated new Ireland could emerge. But a lot does hang on that point. If we were to continue with the current Assembly and Executive, well then the human rights and equality situation of people living in the north would largely remain unchanged. Granted, the sovereign power in Dublin could do what the sovereign power in London can currently do and legislate for matters that are devolved. But that rarely happens as it is at the moment. It's only really when the politicians here can't agree on something that we get legislation from London to fill the gap. I don't think it's going to be any more common for Dublin to interfere in northern affairs if we still had a devolved government here. The position under public international law, if there were a united Ireland, and let's say the Assembly and the Executive and the whole Good Friday Agreement are replaced, the position under public international law is that Ireland takes over the international legal obligations towards the people living in the north. Anybody living in the north who is absorbed into United Ireland would be required to get the benefit of all the international protections which the Irish government currently gives to people living in the Republic of Ireland. Likewise, under the Good Friday Agreement, and let's hope that the principles of the Good Friday Agreement are maintained even if the institutions aren't maintained, there will continue to be a need for equivalence of rights between people living in the north and people living in the south. So any additional rights that people in the north currently have over what people in the south have would need to be maintained and indeed extended to people in the south. If we had had a Bill of Rights by now in Northern Ireland, which goes way beyond what we currently have in our common law and way beyond what the people living in the Republic have, then the content of that bill, under the Good Friday Agreement, ought to be emulated in the Republic as well. Now, the Irish government has always been very much in favour of a Bill of Rights for Northern Ireland. It has never openly said that it would copy it in the Republic if one were to be enacted here, and I doubt personally whether they would do that, or if they were to have adopted the advice of the Human Rights Commission, for example, any of the Human Rights Commission's advice, which say a lot about economic, social and cultural rights. I don't think the Irish government would be quick to imitate that in the south. So the strict position under international law and under the Good Friday Agreement is that there would be no regression on the protection of rights in the north, and indeed there could be an extension to the extent that rights in the south are currently better protected than in the north. I won't go through all the different international treaties, whether UN or Council of Europe, that have been ratified by the two countries. Suffice it to say, to give a couple of examples, for example, Northern Ireland currently benefits from the fact that the UK has signed up to the complaints mechanism under the Committee on the Rights of Persons with Disability, a committee that, given my current walking problems, I have a significant vested interest in, I have to say. People in the south don't have that right because Ireland has not yet signed up to that complaints mechanism. Conversely, the Republic of Ireland has signed up to complaints mechanisms under the Civil and Political Covenant of the UN, under the Racial Discrimination Covenant, under the Torture Covenant, and one or two others, the revised European Social Charter. So if there was a united Ireland, people living in the north ought to benefit immediately from access to those complaints mechanisms. When it turns to the domestic law of the two parts of Ireland at the moment, there is largely uniformity between the degree of protection afforded to people north and south. It's done in different ways. We have, in the north, we have the Human Rights Act, statute law and common law. In the south, they have the same, but they also have the Constitution, obviously, which is far and away the prime document that is referred to by judges in the south whenever human rights issues come up. So the Human Rights Act, which is referred to day and daily in courts in Northern Ireland and in the rest of the UK, is rarely referred to in the Republic. And under the way in which the European Convention has been incorporated into Irish law, it means that courts there cannot invalidate either primary or secondary legislation in the south of Ireland just because it violates convention rights. It's only if it also violates constitutional rights that a court can invalidate the legislation. Another difference between the two regimes is that if there is a declaration of incompatibility under the Human Rights Act in the north, then there's the possibility of a remedial order going through Parliament. And to date, Parliament has always reacted, sometimes belatedly, to a declaration of incompatibility and changed the law to comply with what the court has said. Whereas in the south of Ireland, there is no mechanism called a remedial order. Any declaration of incompatibility, and there have only been 3 so far, I think, in the Republic, the declaration is laid before both houses if they are Oireachtas, and then the government can, if it wants, change the law, but doesn't have to change the law. It doesn't have to in Britain either, but you might also almost say it's now a constitutional convention in the UK that eventually Parliament will change the law to deal with declaration of incompatibility. To turn more specifically to the rights of unionists, It's difficult to imagine really what the ideology of unionism will be in a united Ireland. I imagine they will not be so unwise as to campaign in an all Ireland for a reunification of Ireland and Britain into a new United Kingdom, or to a reversal of the referendum result for a united Ireland. What unionism will fall back on probably is its conservative ideology, both to economics and to some extent to cultural things, to its support for the Commonwealth, to its support for NATO, and its antipathy towards a policy of neutrality such as Ireland currently has. It will support the monarchy, but there are few, if any, chances of the Republic of Ireland and the whole of Ireland voting to restore the monarchy, I would suggest. So it'll become a rather limited ideology on the part of unionism, but they will still form a political grouping, and as such will deserve protection under the law. Now, at the moment in Irish law, unlike in Northern Irish law, but similar to law in Britain, there is no protection directly against discrimination on the basis of political opinion. It's true that Article 14 of the European Convention includes protections against political opinion discrimination, but that has to be linked to a right that's already protected by the European Convention, not to other rights. And there is very little case law, certainly in the Republic, as far as I know, on the extent to which that protection is currently implemented. We differ in Northern Ireland. We have explicit protection against political opinion discrimination, which is one reason, I think, why, if those of you who know about the gay cake case in Northern Ireland, which was decided by the Supreme Court, and it held that there had been no sexual orientation discrimination or political opinion discrimination, largely ignored the fact that in Northern Ireland we have very specific protections against political discrimination. And I maintain that Mr. Lee was discriminated against on the basis of his quite clear political opinion that he supported gay marriage. So in a united Ireland, I think there would need to be better protection for political opinion discrimination, and there would also need to be better protection in electoral law for the particular group of unionists who will refuse to adopt Irish citizenship and go into a united Ireland remaining only as British citizens. As such, they would not currently be entitled either to vote for the presidency, vote for anybody to be president, or stand for the presidency. They couldn't stand for either house of the Oireachtas. They could vote for both houses of the Oireachtas, but not stand. And they couldn't vote in any constitutional referendum in the Republic. So there would need to be changes to Irish law to accommodate that. There is a dispute amongst academics as to whether, under the terms of the Good Friday Agreement, there would be a legal obligation on the Republic of Ireland, or whether there is a legal obligation to extend to British citizens only, i.e. not British and Irish citizens, but British citizens only, who find themselves living in a united Ireland. There's a dispute as to whether the Good Friday Agreement requires electoral law to be extended in their favour or not. So Brendan O'Leary, in his recent book, thinks there is no legal obligation. Oren Doyle, who's a professor at UCD, isn't he, or TCD? Trinity, yes, TCD, thinks there is a legal obligation. I've just done a piece with Tom Hickey from Dublin City University. We agree with Oren Doyle, but not on the basis of Article 1, Paragraph 6 of both the Good Friday Agreement and the British-Irish Treaty in 1998, but Article 1.5 of those documents, I can give you the exact wording if I have to later on. I think the Article 1.5 provision guarantees not explicitly citizens' rights, but electoral rights to people claiming certain identities, and I would have thought British citizenship is a marker of identity. So in any event, morally speaking, it would be right to extend those rights to people, to British citizens born in Northern Ireland at least. Maybe not to British citizens born in Great Britain, but at least to those of us who were born in the North. This common travel area has been mentioned by Colin Murray there, and he's dead right. It's a very important memorandum of understanding, not yet binding in law, but has been in effect for many years, and nobody can see it changing anytime soon, I would suggest. It might be better if it was put into legal form, and it would, again, as said by Colin, it would be compliant with EU law if that happened. So the long and the short of it, I think, is that in a united Ireland, unionists have little to fear as regards their human rights and equality. But it would be good if explicit protection against political opinion discrimination were written into Irish law, and if the election laws in Ireland were changed in the way that I've suggested. Thank you.
Thank you very much, Brice. Really excellent, and a lot of very specific recommendations there as to what might need to change, and reflection of the ongoing debates, and no labels. So, our next speaker is Róisín, who's a QUB doctoral candidate. Róisín is going to be speaking on linguistic minorities in United Ireland, the Irish-speaking community, and I should say is involved in various forms of highly effective activism for a long time. Will form part of Conor na Gaeilge's new committee, who are tasked with a really important piece of work on the recommended constitutional status of An Gaeilge in a united Ireland. Róisín, Cara.
Hello, Choide. I'm very impressed by both professors' extremely polished contributions, so hopefully I can add to them. So, dúise Choide, is mí na mabhuachas a chornúil, mar onadí Conor na Gaeilge, agus phobal na Gaeilge trí chéile a bheith hensa enough. So I'd like to extend my gratitude for the invitation to be here today on behalf of Conor na Gaeilge and the Irish language community to discuss the question of the Irish language as a minoritised one, and to discuss also how its speakers' rights can best be protected in a united Ireland going forward, or in the case of United Ireland indeed. So I suppose, Chorda, while it's my honour to be here on behalf of Conor na Gaeilge, ultimately it's my expertise as an Irish speaker that leads to my contributions today. I recently moved from Caherchurky, or Cork City, to pursue a doctorate in Queen's University, and this perhaps gives me a slightly different perspective on the question of linguistic equality and language rights. I came from a city a few hours down the road whose Indigenous place names were constantly to be seen on most, if not all, official state signage. I had the pleasure of studying and working in universities who promoted the language by means of visibility and accessibility. So too did I have the luxury of contacting a language commissioner in the case that the state's obligations to our language were not being fulfilled. And I was, albeit sceptically, reassured by the legal protections offered to An Gaeilge in Bunreacht na hÉireann, or the Southern Constitution, and other legal mechanisms. Unfortunately, however, as I crossed seamlessly from Dundalk to Newry, these rights, however flawed they are, were ultimately deprived of me and my community as Irish speakers. Just as kilometres changed to miles, Indigenous place names changed to anglicised alternatives, An Gaeilge no longer to be seen, a commissioner no longer to be contacted, and no constitutional protections to be exhausted. So before I address any future arrangements of language rights in the case of United Ireland a Chorda, I believe it necessary to provide context of the historical question of language rights in Ireland and up to the present day as well. So the deprival of language rights in Ireland and in the north of Ireland can and should be traced back to a colonial history. The Anglicisation of Ireland and deliberate state policies that were implemented consequent to centuries of British and Irish conflict meant that Irish speakers lived in an incredibly antagonistic and often dangerous environment. Historical examples of these include the 1366 Statutes of Kilkenny and the 17th and 18th century penal laws, which created a hostile environment for Irish speakers who were subsequently marginalised and even prosecuted for using, educating and living through their native tongue. Nevertheless, more than half the population remained Irish speaking until the census of 1841, and with the arrival of the Great Hunger of 1845 to 51, Irish speaking Ireland was near decimated through death and emigration. Significant progress had been made in later years as a result of the cultural revival of the 19th century. The formation of Conradh na Gaeilge in 1893 heralded a new era for An Gaeilge, and the organisation functioned as a beacon of hope in the pursuit of language revival. The establishment of the Irish Free State in later years saw a continuation of the philosophy of cultural nationalism, while the remaining 6 northeastern counties formed part of Northern Ireland, whose destinies proved to be very, very different. Following the creation of the Northern State, the unionist regime considered the Irish language a threat, one that promoted disloyalty to the Union, and the unionist regime so too considered Irish speakers as a movement of anti-British counterculture. This resulted in the cutting of funding, the banning of Irish language street names, and the threat of imprisonment for speakers and Irish school founders. This blatant sectarianism also alienated the Northern Protestant community from the language, who, in significant numbers, had previously embraced An Gaeilge as a shared treasure and a shared heritage. The Irish language community in the North were therefore left with the task of grassroots language revival and language promotion in a state that simply did not want them. Indeed, they often did so in a time and in communities that bore the brunt of state repression. In recent years, we've been celebrating the 50th anniversary of the establishment of our first Irish medium primary school on the Shaws Road, Bunskull Phobal Ferste. The founders of that school worked tirelessly in a spirit of self-reliance, despite facing incredible resistance from the British state and from the Education Department, who threatened them with imprisonment for their efforts. It would take that school until 1984, a total of 13 years, to be recognised as an official one. Now, 50 years later, we have over 30 Irish medium schools with over 7,500 pupils, making it the fastest growing sector in the North. The fastest growing education sector, I should say. But unfortunately, however, that demand is not reflected in state support. Over 60% of this sector is still in unsuitable or temporary accommodation, and much needed developmental assistance continues to be blocked and frustrated on an ongoing basis. Dr. Robin McVeigh has also outlined in recent research how, despite some significantly positive changes, the state's statutory duty to the development of Irish medium education has not been entirely fulfilled since its introduction in 1998. And this, Sahorda, is very much a case of a battle a day. Following a 30-year conflict in the North, the Good Friday Agreement was signed in 1998, 6 months after I was born. This was to be a watershed moment for Irish language speakers, as a new era of equality was promised for our community by the British government. They vowed that they would take resolute action to promote the language for the first time in the history of the Northern State, making specific and strong commitments regarding the promotion and the protection of the language. Despite these commitments, however, the Irish-speaking community has been continuously obstructed in using the language, and continuous attacks have been made on those who choose to live their daily lives through Irish. Successive agreements, including the St Andrews Agreement in 2006, promised an Irish Language Act, but this has still not been delivered. More recently, Irish language rights issues have been central to tensions within the post-Good Friday Agreement power-sharing government. attacks on the Irish language were one of the main issues that led to the collapse of the government executive in 2017. Rights for Irish speakers became the cornerstone commitment of the restoration of the government following that collapse. And in January 2020, after 3 years without a functioning government and the failure to agree to an Irish Language Act, all political parties and both governments finally signed up to language legislation in the new decade New Approach Agreement. It was an historic agreement, albeit falling far short of what was promised to our community back in 2006. The Irish language legislation will not be a panacea for all of the problems that our community face, but it has laid a legislative foundation upon which our community can build, something that was never afforded to us before now. We are not naive, however, to the challenges which this legislation will inevitably face, and each and every aspect of this legislation is subject to approval from the Office of the First and Deputy First Minister, which, per the most recent election results, would be occupied by a Sinn Féin and a DUP minister. The DUP have demonstrated time and time again that they do not and will not offer rights to the Irish language community. This situates Irish language rights in the very precarious and the very dysfunctional context of the Stortment Executive, an unpredictable institution which is liable and prone to collapsing under political pressure. A united Ireland would, in the most ideal scenario, provide us with stable, secure and local governance, a governance which would be impervious to ideological vetoes and institutional impediments. And although political parties and the British government try to reassure us that the legislation will not be long, 17 years of missed deadlines, unfulfilled commitments and false dawns tell us otherwise. Our community is justifiably sceptical of the British government and of the political institutions' ability to deliver on language rights. We still await the appointment of a commissioner or any practical effect of the legislation introduced in June of 2022. This, of course, follows a similar pattern of non-compliance from the British government regarding the Council of Europe's Charter for Regional and Minority Languages. This was ratified by the British for the Irish here in 2001, but in each and every monitoring report from the Council of Europe's Committee of Experts, COMEX has been consistently critical of the British government for their lack of compliance on the core components of the Charter. The British government and Good Friday institutions assumed that the toxic legacy of state and Irish language relations would simply disappear in a new dispensation. And with hindsight ahorda, it is possible to suggest that this approach was naive. The status of Irish has been contested in Ireland for centuries. The teaching of Irish ridiculed, repressed and prohibited. So the notion that a clean slate was possible without dealing with the root causes of the conflict was a mistake, and a mistake that we can and we should learn from. The Northern state has not been able to reset its relationship with the Irish language. And unfortunately, ahorda, the socio-linguistic conditions in the Southern state do not inspire much confidence either. Despite the enshrining of the Irish language into the Constitution of 1922 and further consolidations in that of 1937, Senior Judge Una Ní Rafferty of the Irish High Court has claimed that the constitutional status of the Irish language appears to float at an abstract level. Indeed, one would be wise to question the utility of the protections offered in the Constitution and in the Official Languages Act of 2003 and 2021 when considering Ní Rafferty's claims that the Irish-speaking community faces surprising intolerance towards its rights from quarters usually more respectful of minority rights. Other significant contributions from Ní Rafferty include her outright criticism of the quality of translation services in court systems and her claim that other linguistic minority communities are even offered preferential treatment in translation services in Irish courts than what is afforded to Irish speakers themselves. And this all echoes Conor na Gaelga's concern, as articulated in 2021, that there exists a significant difference between official state rhetoric and actual state policy towards An Gaeilge. Indeed, the first language commissioner in the South, Sean O'Crowan, stood down from his role in 2014 in frustration and in protest against government inaction towards language. More recently, our community has been victim to the likes of Leo Varadkar and various politicians expressing a potential willingness and, dare I say, eagerness to sacrifice the language in the case of a united Ireland too. I could spend another few hours, unfortunately, discussing other examples of state negligence in Garda and the essential futility of whatever language rights we do hold. But remember that this is only the tip of the iceberg. So my contribution thus far has dealt with past injustices and violations of basic rights as suffered by the Irish language community, both north and south. And this is not intended as a grim account of our past woes and misfortunes, but rather to serve as a foundation for what will not be tolerated in a future shared island. Our history and the significant impact of colonialism should be central to our understanding of the past and the present. Indeed, it is of paramount importance to informing our future. If we were to do this, I have no doubt that this would result in genuine political outcomes that protect and ensure the implementation of rights. In addition, the recognition of our unique history in a wider global context, alongside the effective implementation of agreements, would begin to address the root causes of the conflict and thus offer the most effective means to build a shared and an agreed island. And conversations regarding a new constitutional arrangement on the island of Ireland are growing. And recent debates about a united Ireland have seen the role of the Irish language placed front and centre. It really is an exciting time for our community, and we embrace these conversations with hope, with confidence, and with a vision for a brighter future. Our lived experience, however, reminds us not to be naive, and we know to strive for more rights and more protection than ever afforded to us before. We will not accept a regression on what limited and flawed rights we enjoy in the South. We certainly will not accept the total absence of basic rights as in the North. We will use this opportunity to correct historic injustices and to create a society of equals. Conradh na Gaeilge will lead this conversation in the context of Irish language rights. We plan on assuming this responsibility by creating a working group whose remit will be to prepare a report on the recommended constitutional status of An Gaeilge in the case of a united Ireland. This report will examine the current legal standing of the Irish language, both north and south, and will provide a comparative analysis between Ireland and other bilingual countries as a means of emanating best practices elsewhere. We hope that this will facilitate the Irish language community to participate in the ongoing and vibrant civic debates regarding Irish unity in an organised manner. We hope too that it will provide a blueprint for the protection and the further development of the language and Gaeltacht communities in future constitutional agreements. The report will therefore be crucial in agitating for language rights in a new and a shared island. So, Garda, we must learn from mistakes, ensure they don't happen again, and also learn from successes over the years too. We must consider the constitution, education, the Gaeltacht, language promotion and protection, and the effective implementation of legislation, along with socio-linguistic issues impacting on communities across Ireland. To do so, we must encourage broad, inclusive and comprehensive debate, and we must provide spaces, such as today, for language communities to participate in a conversation that will undoubtedly have an impact on us all. It is incumbent on us all to put the revival and the reclamation of the Irish language at the core of the debate and to protect the language from those who would use any future change to exclude and to marginalise the language and its community. Irish speakers need to be involved as we must ensure that the interest and the needs of our community and of the Irish language and Gaeltacht communities are at the centre of the debate and put in a thematic and focused way. So we shouldn't ignore the conversations about a new Ireland to Garda, and conversations like this give us all hope, I suppose, for a better future. We should continue to actively participate and investigate the challenges and, more importantly, the opportunities that constitutional change presents. It's our responsibility to do so.
Róisín. Now, thank all our speakers for wonderful presentations, giving us much to think about. Conscious of we've got a bit of time for questions in the room, and I'm going to ask whoever's got access to any online presence on the chat, if any questions come in the chat, just, Marie, if you could just let me know what they are. But we've had a lot to think about there in terms of what could happen, what some of the questions are, and what the options are, what must happen as well. So really over to you. We'll take a range of questions from around the room, and we'll bundle them all together, and we'll present them, I think, to each of the panelists, give each of the panelists a chance to talk. If you could let us know who you are and where you're from, that'd be great. So any questions? Daniel has already, so Claire.
Hi everybody, my name is Claire Wright. I'm from Queen's University, Belfast. It's a really interesting panel. I was thinking in terms of constitutional change, imagining futures, and minorities specifically. Often we speak sort of for minorities, about minorities, and they're not speaking for themselves. And Róisín, you were saying that at the end we need to participate, we need to provide reports. So my question was, in terms of imagining this future, what is the role of minorities themselves? What sort of spaces are people thinking about? Is there such a thing as a constituent assembly? Could there be participatory mechanisms so that those voices are heard? Beyond kind of legal obligations, how might that look? And also identifying the minorities, because you may have majority that becomes minority, and obviously minority is a relational category that's going to shift. So beyond the sort of legal formal obligations, how does that kind of lived experience, how could that come through when it's sort of crunch time, when it's decision time?
Person who I don't know at all here.
Yeah, thanks to all the panel members. That was
who are you? Just for the audience.
Daniel Holder, CAJ. I have a question for each of them. I'll try and rattle through them. Brice, first, you've mentioned the issue of potential transitional arrangement for the executive and legislature in the north. I just got thinking about what about the legal system in terms of would Northern Ireland retain, either as a temporary measure or even in the long term, if you think of Scotland, even pre-devolution, retain a separate legal system. I suppose what I'm thinking about is how messy is it going to be to merge two legal systems? So thoughts on that. Colin, we always have this issue of terminology and what to describe. There's no agreement on even the names of different communities across the sort of ethnic divide. There's no agreement on what we call these two islands, but yeah, description as a small damp archipelago, I think, has to be picked up in some future treaty.
Invest in I logo of the future, I can see it.
But I'm just thinking about the issue of the common traveller and the potential for the two governments to talk about trying to draw an external border around the two islands, which is what they were kind of trying to do through Brexit. I'm assuming, particularly from a British government's perspective, that's dead in the water at the moment, in the sense of Brexit, free movement of the island and things like that, that ain't going to happen. And then finally, Róisín, I think, firstly, you reminded us that both of the universities in this jurisdiction have really stuck with the old English-only policies of the previous unionist government. They've resisted the Good Friday Agreement framework cooperatively of linguistic diversity, provision for the Irish language, etc. What you got me thinking about was the issue around this issue of if there is a transitional arrangement of the maintenance of a Northern Ireland executive, the risk of that, I suppose, from the Irish-speaking community's perspective is that everything will continue to be vetoed. So if that was the case, would some sort of constitutional protection for the rights or whatever be needed to sort of underpin a basic set of rights that couldn't just be unpicked by an assembly veto in this part of the Northern Ireland?
Thank you very much. Rory and Fidelma, and then we'll go back to the panel, if that's okay with. Good.
And just if the panelists can go back to the microphones, just to answer the questions, make sure we get it for the audio. So I have an online question from Professor Noonan Elaine, who will be joining us shortly. Given the abject failure of the Republic of Ireland to protect and promote the Irish language, why would we think protection would be any better in a united Ireland? And let me just tag on to that. We're talking about minority rights in a united Ireland. Will Conran and Gaelga also be addressing or considering policy in relation to Ulster Scots, to Traveller Cant and Gammon, and other minority languages?
Look, thanks everybody. There was a lot of content in each of those presentations, so I'm going to try not to make my question 10 minutes long.
Don't make a question 10 minutes long.
So look, Colin's framework of mutual advantage that the best way to develop towards any kind of constitutional change is for the mutual advantage of peoples on both sides of the British-Irish border, or whatever you want to choose to call it. So that's a great framework. And then Brice is saying we have already, between the two jurisdictions, very firm foundations in terms of, let's say, particularly liberal rights, for example. Oh. So, yeah, I think that's great, but the thing that keeps coming into my head is that while, you know, we could have that framework and we could build upon that framework, we keep coming back to the zero-sum game with rights. So the zero-sum game with rights is going to continue to be around linguistic pluralism, around cultural rights. And these are kinds of specific rights that are going to really be an issue when we start getting into the nuts and bolts of any kind of real practical constitutional change. So we could go for what Colin said about, you know, unionism is simply a minority in line with a whole lot of other minorities, and I think that's Jennifer Todd's argument in that 2021 paper. But there is another level of legitimacy, I think, that comes with unionism that we have to think about. So I was just wondering if you had any thoughts on that. I know that was longer than I intended.
Well, thank you very much.
There.
So we have questions from Claire, Daniel, Rory, Fionnuala online, and Fidelma. And I was going to ask each of the speakers, perhaps, over the course of 3 minutes each, to respond to a range of those questions in the order that we started with. So Colin, if we could go first, that would be great.
3 minutes. I was going to take this opportunity to extend upon my paper by another doubling of time at least, but Colin has put those parameters on it. Thank you for a really rich range of questions coming in that I will not do justice to. Claire and Fidelma, if I could take your questions and perhaps merge them together. I think writing with Aoife O'Donoghue in a recent paper in the King's Law Journal, I think we lost something really significant when we lost the Civic Forum. And the Civic Forum gave a really powerful platform to allow multifarious voices that do not come into our political system through the electoral process to be heard. And I think in any form of preparation towards constitutional change in this island, and that's whether it succeeds or not, that entire societal debate will change some things about how this place works, even if statehood doesn't change. But at the moment, the idea that unionism would just be a minority amongst minorities is counterbalanced by its political weight and its ability to assert political weight in a way that marginalized groups in our society cannot assert at the moment. And the absence of the Civic Forum prevents there from being any space in which these things can be addressed. And it, for me, is the most pressing institutional shift that I think is necessary to at all give life to this in a holistic way and to prevent the continuing marginalization of those voices, is for something to be restored that comes into that sort of space. Dan, the idea that any sort of CTA arrangement is dead in the water, I suppose it comes back to that idea of there was that effort to put it into a memorandum of understanding. How much further could be gone in that? I suppose prior to 2016, there were so many efforts to do things like visa waiver schemes. The common travel area was seen as something active and advancing, and that there would be improvements for groups of citizens from other parts of the world who came onto one of these polities, moving around the others. And I think we need to get back into that space of seeing it not as being still, and that particularly around large refugee communities who have moved in light of active conflicts at the moment, that there are people with families scattered across these islands who we need to, at an intergovernmental, think that their lives need to be made easier to move between these polities. And that's maybe where I'd start to think about building on what we have at the moment. And I think I'll leave protected characteristics and languages given the time.
Brice, would you like? Yeah. I think it's true to say that, in answer to Claire's question, that unionists have been particularly bad at even wanting to engage in this kind of debate. I think that they are their own worst enemy in that respect. They think that talking about it is going to bring the day of a referendum closer, when in fact the opposite is the case. And I think they should be making more, for example, of the benefits that Brexit might actually bring. And I know it's heretical to say, even to think there might be benefits of Brexit, but insofar as Northern Ireland has now got access to both the UK internal market and the EU internal market, if there were to be a united Ireland, presumably we would lose access to the UK internal market. So that's a reason for the unionists to engage in the debate and say, no, we don't want a united Ireland for that reason. On Daniel's question, I don't think it would be a massive undertaking to change the judicial system. If you mean by the legal system, the judicial system, we do after all have a court system which largely aligns with that in the Republic at the moment. We have 4 or 5 tiers of courts. Obviously, at the end of the day, the top court would be the Irish Supreme Court rather than the UK Supreme Court. But the Irish Supreme Court has been reformed recently through the creation of a Court of Appeal. It now is a much more of a constitutional court than it was, even more so than it was before. It's producing better and better judgments all the time, I think. Of course, there would be unionist opposition to an Irish institution having the last word on any matter. But at the end of the day, the Irish Supreme Court adopts lots of principles that are very similar to those that the UK Supreme Court would adopt. I can't really speak to Fionnuala's question except to say that there might be an indirect benefit to Irish speakers in the Republic if, in a united Ireland, some consideration had to be given to Ulster Scots. I'm the last person to say that Ulster Scots deserves protection, to be honest, but it's there in law. It's covered by the new statute as well, and if special provision is going to be made in the Republic for Ulster Scots, then perhaps even better provision should be made for the Irish language as well. I didn't quite understand what you were defining as a zero-sum game there, Fidelma, when you were referring to rights. You were suggesting that if somebody wins, then somebody else loses?
Well, just to give you an example, if you have signage, Irish language signage, in a particular area,
Yep.
if that were to become a right, then it would be a zero-sum game, because you have one side again asking for particular cultural rights, and you have another side on the other side which sees that request is actually an infringement of their cultural rights, if you understand me. So I think that's almost makes that minority kind of specific in a way, and has to be approached in a slightly different way to other minorities.
Yeah. The current position and proposals for Irish language signs in the north here would not be in place of English signs, but in addition to English signs. Ulster Scots people could, if they wanted, have a referendum, a local referendum, to get a third sign put up.
Yes.
I'm not advocating that, but in theory it's possible. So I don't think it's a totally zero-sum game situation. All sides can benefit, I think, at the end of the day.
Well, I know I agree. I think all sides can benefit, but whether they would want to benefit is, of course, a different
Oh, that's another
issue
question.
around
Yes,
here.
that's right.
Good stuff. So I'll start with your own question there, Claire, in terms of minorities and how we can identify them first of all and then protect their rights. Well, I suppose the most important thing we can do to get minorities to participate in these conversations is to democratise them and to make them accessible. I think sometimes these type of environments can be daunting for people. They're loaded with legal jargon and terminology and all these references to different agreements and statutes and whatever else. So we need to democratise it, go out into grassroots communities, engage with communities on the ground, and just make these conversations a bit more inclusive and a bit more accessible. The second thing I would say is, how can we identify them? Well, I suppose ultimately that depends on the communities to come forward themselves and to agitate and to organise for their rights. And the Warm House will be there for them to participate in those conversations once they want to. As you said, I don't think it's up to different communities to prescribe who and who cannot participate in the conversations. So it's up to themselves, I suppose. So Gramagat for the question. And I might add as well, I might speak more as an Irish speaker as opposed to a representative of Conor na Gaeilge in these questions as well. So the next question then was from yourself, Daniel. How can we prevent vetoes in the case of United Ireland when it comes to Irish language rights? Well, this absolutely cannot be allowed in the case of United Ireland. The days of political vetoes must be gone, and there can be no tolerance for them whatsoever in future constitutional arrangements. So what I would suggest we do is we look to best practices elsewhere. And one of the most, I suppose, pioneering examples or the most effective examples would be Canadian constitutional law, who have put together fantastic legislation in terms of linguistic equality in New Brunswick. So, for example, in the Canadian Constitution, there is equality of status and equality of rights and privilege guaranteed in that legislation. And it includes the right to distinct educational institutions, which would provide for the preservation and the promotion of those communities. So that's a really trailblazing piece of legislation that we can look towards to, first of all, prevent political vetoes, and second of all, to encourage the promotion and preservation of our communities. And then the final question, so why should we think that the Republic will change, or why do we think Irish language matters will improve in the case of United Ireland if the Republic hasn't managed to do that so far? Well, the first thing I would say there is a United Ireland, in my eyes, is not about assimilating the North into the South. It's about creating a new Ireland. It's about creating a new society and a more inclusive one where we learn from best practices, North and South, put them all together to make a better country for all of us. So it's not about replicating or emanating what we have done for the last 100 years and ultimately failed to do, but it's about creating a new society. And we can look to international context to see how this works in other places and to emulate best practices. So again, we absolutely don't want to repeat history. We want to learn from the mistakes. So we're not even starting with a tabula rasa or a clean slate. We're actually starting with 100 years of experience of failures and successes too. So that's our starting point, I believe. And in terms of Ulster Scots and Traveller Cant and other minority languages on the island, I suppose Conor na Gaeilge, and I'm saying this as a member as opposed to a member of staff or anything, I suppose Conor na Gaeilge's priority is to deal with the Irish language. Having said that, the Irish language community have always operated in a spirit of solidarity and community solidarity. So if members of Ulster Scots linguistic communities or members of the travelling community want to participate in these conversations, we will show absolute solidarity with them, and we'd welcome to discuss and to contribute to these discussions on linguistic minorities in the case of United Ireland. So just in terms of the zero-sum rights then, Fidelma, to finish off, I suppose the question of language signs is actually, it's constantly brought up, I suppose. And I'd urge everyone, and I suppose, just to be careful in terms of the wording we choose here as well. We're not looking for Irish language signs. We're looking for dual language signs. We're looking for equality. We're looking for both languages to be put there to show equal rights for both linguistic both linguistic communities. So we're not looking for supremacy. We're looking for equality. So there can be no case of violation of those languages' rights, which should be based on equality and good relations. So, Sinead Soka, Gurmahaga.
Moy Shiv, Harja. Well done, everyone. Really, really excellent panel. A lot to think about there. We'll now draw the session, panel 1, to a close on minority rights. 3 points to finish on, I think. What we're really talking about today and this afternoon is about the choices that are there, and we've explored one of those choices and the options. the sense that people are going to be asked the constitutional question. The principle of consent is ever present in our society. At some point, people will be asked the question. It's there in the existing frameworks. Uncontroversial, unproblematic, sensible, responsible is what we're doing this afternoon. It's about essentially making an informed choice. We know what we're voting for. We're all living the dangers of doing the opposite, right? So that is what we're doing today. And absolutely centrally, and to end, moving on to the next panel, it's how do we make sure equality and rights are at the centre of conversations that are gaining ground, that are getting traction. And so I just want to end really by commending Rory, TJI, Equality Coalition, Daniel, the Gender Justice and Security Hub for organising the event today, and move on now to the next session, absolutely essential session on women's rights in new arrangements. So thank you all very much.
Thank you, Colin. We'll take a 10-minute break, folks, and we'll convene at hour for the second panel of the day. So thank you.
Good afternoon, everyone. If we could settle down. Thank you very much. I hope you had a good break. We're in for a very exciting session. My name is Patricia McKeown. I am the Regional Secretary of the Trade Union Unison, and I have the pleasure of being the co-convener of the Equality Coalition, along with my colleague Daniel from CAJ. I've also got the pleasure of introducing to you this afternoon some astonishing women. I'm a feminist. I'm delighted to be taking part in this kind of discussion, a discussion which is going to run for some time about what the future of our island might look like. As a feminist, as far as I'm concerned, that whatever that future looks like, if women's rights do not have primacy, then it's not the right, it hasn't been the right settlement for me. And I think many, many women feel that way. We have, first of all, Fionnuala Ní-Shéalainn, and Professor Ní-Shéalainn is no stranger to anyone who's been involved in human rights on this island, or indeed much further afield. She's just finished a very significant second term as the UN Special Rapporteur on the protection and promotion of human rights while countering terrorism. She is concurrently professor at both the University of Minnesota and a law school, and indeed our own Queen's University. And she has such a prestigious list of awards and achievements. Some of you will be familiar with them. Many honours, Fulbright and others. And she is an elected fellow of the Royal Irish Academy. She's also published on extensively on the field of emergency powers, counter-terrorism, very importantly, conflict regulation, transitional justice, and sex-based violence in times of war. One of the issues that has been of significance and importance to the women's movement here for a very long time, certainly since the peace agreement, has been the refusal of the UK government to designate us as ever having taken part in a conflict, and therefore we don't have the benefit of UN Resolution 1325, and that's one of the areas that Fionnuala is going to address. Fionnuala, we also have a much more parochial affiliation with you. You were brave enough to be one of the legal experts for a whole year in the 2010 process, where we tried to build a comprehensive, enforceable Bill of Rights for Northern Ireland alongside all of our political parties. We didn't get too far. We got very far with the exercise, but we didn't get very far with the response from the UK government. Wonderful to see you again. And all of our contributors are going to try and confine themselves to 15 minutes. So I would give the floor to you now, Fionnuala.
Yeah, I can. can hear me. I can now hear you, so thanks. And sorry that I missed the introduction, and really sorry not to be there in person, but really glad to have the possibility to talk and contribute to this conversation. So I'm going to talk about protecting women's rights in a united Ireland. And I think I'll just start by saying very obvious. It's been 25 years since the adoption of the Good Friday or Belfast Peace Agreement. It's heralded this transition that, maybe perhaps unending transition that we've been in. And it's just a note that to tell us all that transitions are long and slow and they don't always end up where we anticipate they'll end up. And the work and the progress through transition is really hard and unrelenting, particularly for human rights. But I want to focus on the first pivotal article of the agreement itself. And in many ways, that pivotal article, and I recall a piece of work written by Colin Harvey, myself and Colin Campbell some years ago, that talked about the ways in which this article undoes traditional notions of the inviolability of sovereignty and territoriality. And of course, the one thing that that opening article does do is that it opens out the prospect for a referendum on a fundamental change to the political status of Northern Ireland at some unspecified and future date. And I think it's just, I'm going to read the article because I'm actually going to talk very closely about some of the language in that article. And it says it's for the people of the island of Ireland alone, by agreement between the two parts respectively and without external impediment, to exercise their right of self-determination on the basis of consent freely and concurrently given north and south to bring about a united Ireland if that is their wish, accepting that this right must be achieved and exercised with and subject to the agreement and consent of the majority of the people of Northern Ireland, end quote. So we're a quarter of a century on or so from that Good Friday Agreement, and we're in a post-Brexit context, and this debate about Irish unification is now often focused on the practicalities of what it would mean to make such a referendum happen. But I think one of the things that's really important that I think we're starting to do now is to break down these constitutional conversations into a range of issues and to understand the repercussions of those issues. And I want to talk about what it means for women's rights. And so it's worth reflecting on what the gender of that first pivotal article of the agreement is. And I just want to start out by saying that in general, the history of self-determination has not served women well. More particularly across multiple post-conflict and transitional contexts, the term self-determination has functioned theoretically as a neutral concept, but in practice it's a highly patriarchal way to advance notions of self-determination that prize territory above people, and in particular the female bodies that inhabit those territories. The language of self-determination has often required women to subsume their agendas for equality and gender transformation to the abstract goal of a certain kind of insular territoriality and sovereignty, which in a way puts these symbolic values of territoriality and sovereignty above all other values, including women's rights. And more often than not, what we see happening is that this kind of discussion about self-determination has a kind of a hierarchical determinism that essentially operates self-determination as a trump card to occlude and to limit the exercise of other rights. And so it's also worth paying attention to the language of people in that first article of the Good Friday Agreement. And I want to point out that people is a classical kind of terminology that's used around the self-determination. But there's almost no agreement in international law on who the people are for the purposes of self-determining. And again, people is seen as a kind of a coded neutral term. But I would want to say that people has a coded, distinct, and historically embedded meaning. And what that is, in my view, is that it's specifically the people are the men who agree the terms and the basis upon which the process towards unification or self-determination happens. And so the importance here is noting of how political processes who decide upon the question, i.e. will a referendum be facilitated, these parties are predominantly male. And I don't need to recount for this audience the demise of the Women's Coalition, the enormous barriers facing women entering into and staying in political life in Northern Ireland and in the Republic of Ireland, and what feminist international scholars, including myself, have called the nested institutionalism of masculinities in political culture, which is found both north, south, and east of the border that we're talking about. So as we reflect on preparing for unification, I think feminists have to come to this stated project with a great deal of skepticism. Because I think what we see is the collusion, generally, of male elites on all sides of the political parties or political space. We see collusion on issues like women's autonomy and reproductive rights. And as our post-agreement history in Northern Ireland tells us, this doesn't work well for women. The second thing we should reflect seriously on is the embeddedness of sexual violence and the acceptance of misogyny in public and political life, perhaps best reflected by the rugby rape trial, in which the most elemental things that we teach our students in criminal law about how women's narratives of sexual harm will be drowned out by a legal process which eviscerates the female voice and female experience to the dominance of the man's perception of what is acceptable to presume about a woman's consent to violence and harm. All of these things are true, north and south of the border. And so again, to state the obvious, we wonder why women don't report sexual violence, but more broadly, what is the community of experience into which this discussion about unification or preparation for unification falls. And I think in civic space, it's worth reflecting on the continued challenges for women-led civil society in Northern Ireland and in the Republic of Ireland, who continue to be failed inadequate funding, and who continue to be failed in actually delivering their capacity to translate the immediate goals of civil society into actionable policy and practice which will be observed by government. And so my point is generic, but I think it's a pretty powerful one, that the, quote, agreement and consent of the majority functions in a universe of inequality, of structural and systematic lack of representation for women, north and south, and all the more so for LGBTQ and gender diverse persons, women of colour, traveller women, Irish-speaking women, and there I include myself as an Irish-speaking woman from the west of Ireland, whose capacity to have voice in the Republic of Ireland as an Irish speaker is virtually nil. And so if we're imagining what gender equality might look like in a united Ireland, we have to take a fundamental step back and ask, what are the a priori conditions that create a process that could lead to a mainstreaming and centralization of gender and women's rights in the pursuit of a new form of political coexistence on the island, and actually perhaps step away from the language of unification, which may in itself be fundamentally divisive to the inclusion of large swathes of women on both sides of the border. And so all I want to say is that we have few good precedents to do this well. Transitions have generally not been good or kind for women, and those of us in the room who study transitional justice have evidence from South Africa to Chile to Eastern Europe and elsewhere to tell us that actually we don't do transitions in a way that generally work well for women. And conflict transformation, as evidenced by what I see as the abject failure in many dimensions of the global women, peace and security agenda, has actually simply not delivered for women over the past 2 decades. If the bargain for women in the women, peace and security agenda in armed conflict was protection, it has abjectly failed, whether that is in Afghanistan, Yemen, Syria, or Gaza this morning, where actually to even speak of a women, peace and security agenda is a waste of breath, because it means nothing for the women who are suffering on the ground. Whether it's in terms of peace processes, just think of the Doha Agreement and the Afghan women who sat on the sidelines for over 2 decades. And the fact that the United States and other parties, including the European Union, felt that it was okay to leave Afghan women sitting on the sidelines was actually the precursor to ensuring that the kind of language of gender apartheid, which is what my colleagues on the Working Group of Discrimination Against Women now call, this is where we landed. But we didn't just land there because of the Taliban. We landed there because of the collusion and exclusion of women's voices in political change. Why should we expect, or do we see anything different happening in this discussion right now? And I would also say that in the consociational agreements from Bosnia to Belfast, which Rory and I have written about at some length, and others in the room, women, frankly, have just not done so well, as ethnic elites and ethnic entrepreneurs have colonized that space to advance their own nationalistic ends. So with all of that, which is really just the tip of the iceberg, I would say that to imagine a process of unification that serves women well, we need an amplification of women's inclusion in every foundational process of deciding what the future of the island looks like. And that requires asking, we use this word unification like it means something, but actually the meaning, the constructive ambiguity of that term means that there's a whole lot of different understandings embedded in that, but almost none of them include women in a meaningful way. The second thing I think that's clear here is that compromise will be required on this fundamental shift in territorial and sovereignty. And to be honest, women don't do so well in those compromises, because generally they're the flotsam and jetsam that get thrown out along the way. And more fundamentally, what would a future of equality on the island of Ireland really look like, regarding women both as a category in their own right, but as an intersectional category that encompasses minority religious views and minority religious status? And women there shouldn't be an add and stir. Maybe the test of the agreement is how well it will serve minority women and marginalized women with a marginal political status, not what it does for the majority. And so my profound concern now is that the only template we have for this discussion of unification is one that's largely based on nationalistic, read in brackets, masculine tropes of territorial unification between one state, Ireland, that has historically discriminated and defined women out of public life, and another entity, read Northern Ireland, that has also discriminated and defined women out of public life. And this is not a template that feminist equality or human rights-based discussions would start with. As the man asking for directions on the road somewhere in Ireland would say, I wouldn't start from here. None of us would start from here for women in this discussion. So maybe we need a different set of questions. First, how do we coexist on this island? Second, how do we address the fundamental needs and rights of all persons equally on this island? Third, how do we move from territoriality to personhood as the defining positionality of moving into a different imagined political space? Fourth, where are women in this conversation? Concretely, and more concretely, how are they included? Fifth, where are the most marginal women in this conversation? And finally, how could we make for an entirely different conversation from both the academic and the political elites, one that's entirely different from the conversation that academic and political elites seem intent on perusing? And that would be the conversation that I, for one, would be interested in having. Thank you.
Thank you very much, Fionnuala, for setting out the template for us. I can't see anybody disagreeing with that one. Now, building on it, we're moving directly to Professor Fidelma Ashe. Professor Ashe is Professor of Politics and she's a member of TGI. She's an expert in gender, sexuality and peace building, and her recent work has examined the participation of women in constitutional change on the island of Ireland. And Fidelma, I think, this dovetails in very nicely. You're very welcome.
Thanks very much, Patricia. So, first of all, thanks to Rory for the invite and Daniel for the invite and whoever else organised this. It's great to be here. It's great to be here with so many voices looking at this from different angles. And it's so huge. It is so huge that sometimes you think you really don't know where to start. But I suppose I want to follow on from Fionnuala's brilliant presentation there, and maybe just look at some practical aspects of the inclusion of women. So maybe we're moving the slide. Okay, so I mean, one of the ways that I suppose you can protect women's rights is that if if a new constitution is ever developed, created, or agreed, well, what you can push for is to entrench a set of gender rights and protections in the national constitution. Now, this is why sometimes feminists view constitutional change or any kind of transition in a society as an opportunity where a sort of a space opens where women can start to make claims and rights-based claims in a kind of shifting, more fluid context. So, so if you look at, for example, there's a UN Women Report 2017, and that gives lots of examples where transitional societies who have developed new or renewed constitutions have been able to insert protections for women in their constitutions. So an easy example is the right of women to participate in public life, or the responsibility or duty of the state to protect women across a whole range of areas. So that's one way you can do it. Now, you can do that through having a group of constitutional feminist lawyers, and they can write up a set of protections for women based on sort of international standards and existing case studies of what has happened. Now, you may definitely need gender experts and legal gender experts and constitutional feminist experts, but I have come to believe that, Rory, can you move the slides? I have come to believe that you need much wider and much broader women's participation, okay? So you can say, well, women have a right to engage in constitutional discussions, or the shaping of constitutional change, or the shaping of visions of the nation, as Fionnuala quite rightly points out. Some of that has been absent in the past. So you could say, well, there's a democratic right for a woman to participate in these conversations. But I would argue that there is another very important aspect to participation, not just of women, but of all minority groups. And of course, we really can't draw a sharp division between minority rights and the rights of women, because of course women are a very pluralistic group with cross-cutting identities. But looking at some international case studies, examples, I think it is possible to see that wider constitutional participation by women or minority groups has a number of counter-hegemonic effects. Now, what do I mean by that? Well, if you look at the Repeal the Eighth campaign, that really wasn't just about gaining rights. That changed fundamentally how the society understood women's rights, women's autonomy from the state. The whole concept of morality and reproductive rights was actually turned on its head and shifted from the morality of the woman to the morality of a state, that would allow women to be harmed and women to suffer. So there's rights, and then there's the context of rights. I keep pressing this and hoping it will move. So those sort of counter-hegemonic challenges can start to affect what Fionnuala was talking about. I think the term she used was universal patriarchal practices or ideas. So I think those are really very, very important, those public sphere challenges by women to contest, question, expose the kinds of, well, let's use the term patriarchal because it's familiar to most people, those patriarchal relationships that have been embedded in our cultures for a very long time. So if you think about women's participation in these discussions, if you think about what's happened in other societies, you can have a system of civic education and dialogue, and women can start to develop their own visions of our histories, or certainly assert them into the conversation. They can question the hierarchies of identities that Fionnuala was talking about. Overall, if I were to summarise that, just too many men. And then, you can have a hierarchy of priorities, because we know even from the discussion this morning, we cannot get away from a set of priorities with constitutional change. But we can challenge them, we can question them. And of course, the other aspect of women's dialogue and civic education to support that is that women can make, in all their diversity and plurality, they can make existing gender power relationships visible, whether it's north, south, or a mixture of both. Now, I think this is really, really interesting, because sometimes when we talk about cultural change, people can think, well, that's not black letter law, that's not international law. I'm not saying anyone in this room, but I'm just saying someone might think that. It's all a bit waffly, it's all about culture, and we know about that, and shifting identities and all this kind of thing. But I would just like to show a very practical example of that. So there was a fabulous piece of work undertaken by, I think it was UN Women, but I'll double check that. I should have put it on the slide. And they looked at constitutional jurisprudence. So people taking cases, taking legal cases that, what had happened, or a law was to them, or a law that had been applied to them was not constitutional. And in these cases, they looked at 63 cases across the world, and in terms of family law, CEDAW, which is the Convention on
the Elimination of Discrimination Against Women.
Exactly. Was used in family law 43 times. So it was used as an interpretive rule in constitutional cases 43 times. But just look at the number of cases it was used when it was representation. 6% of cases. The most common interpretive tool to be used in those cases was a social contextual framework used by the judges. So what they looked at was the power relationships within the existing society, and they made their judgments through that interpretive framework. So for those who say, well, culture is important and all the rest, I think culture and cultural change is really, really, really significant. Now, so The other interesting thing is if you look at those cases, most of them were intersectional. So it was on the basis of two sort of double dual discriminations, okay? Now, the next question, well, before we think about that, I mean, you know, if you think about representation, because representation might become an issue for us. We don't know what the shape of, you know, the constitutional arrangements are going to be, or even what that journey or pathway to it is going to be. But we could end up in a situation whereby, you know, women in the north had higher rates of representation, and then we might move into a different situation where that actually might drop. So we don't know what would happen, because of course there's lower representation in the Irish Parliament, a lot lower. So, you know, there may be a losing out there. So these kinds of issues are really important to us. So the next question, which is the bigger question, is, well, how do you do it? How do you facilitate the participation of women and other minority groups? Well, there are, again, international examples. How am I doing for time? Patricia, am I going way over?
You've got another few minutes.
Another few minutes only, right. I'll try to behave myself. So, look, you know, if we look at the work that's being done on civic education and inclusionary initiatives in other societies, it's phenomenal. So we'll look at the first one because I haven't that much time. But in Uganda, and this is a country with far less resources than we have here, they led a whole process of civic education through the Uganda Constitutional Commission. And they reached 30,000 community leaders who engaged in a whole range of seminars right across the country. Now, women benefited from that process because there was spaces for them to be included. And they did get some protections into the 1995 Constitution. However, when you're dealing with a sort of semi-authoritarian kind of state, ensuring that they're preserved may be difficult. But the point of this really is to show how it can be done. It can absolutely be done, but it requires a framework, and it requires a real investment to educate people, to help them understand, and we all need it. I need to understand, that's why I'm here. I'm trying to understand different aspects of constitutional change from other people that I don't understand. So it is possible, and when you have that widespread participation, it's likely that you're going to capture women. So it can be done. Now, we have been working on participation, and what I would say is you really have to think, well, the lessons that we've learned, I think, is that you really have to think about your identity group, and you have to think really clearly about, well, what are the specific barriers, okay? So you have to think, first of all, about your participatory space. Is there something about it that somebody is not going to want to engage in that space, be it where it's located, or I don't know who's facilitating it. You know, there can be a lot of those things. Resources. Do you need an interpreter? Do you need someone who can sign? Do you need to bring people in remotely because they're housebound? So, you know, each of these kinds of identities that we talk about, they have real practical needs that you have to shape your participatory spaces through. So look, I'm going to have finished my time. So thank you very much for listening.
Thank you very much, Fidelma. And I'm going to move straight on. I know that Professor Newcastle has got a deadline at 5 o'clock, so I want to try and get to questions before then. Not to curtail, our next two very important speakers, and I'm delighted to now invite up Dr. Joanna McMinn, University of Ulster. And I think, Joanna, in your introduction, it says that you have 40 years experience working in and with women's organisations, and I think I've known you for most of those 40 years. Women's education, community-based education, and very importantly, as the very first director, I think, of the Women's Resource and Development Agency. WRDA today has gone from strength to strength, umbrella organisation as well, many women's groups, as well as women's campaign organisations, and very important part of both the coalition and indeed my union. So you have been they need to know who you are properly. You've been the director of the National Council of Women for Women, and you did that for at least 8 years. And you are currently part of the network that is the All Ireland Women's Forum, which I think is operating on within the context of the National Women's Council. On the issue of the conflict, and UN 1325, and whether or not we are actually in a post-conflict society. Joanne, the floor is yours.
Thank you. Okay. Thank you, Patricia, and thank you, Rory, and for this for inviting me. I was very nervous about it, and when I was coming in talking to Isla, she reminded me of a quote by Toni Morrison, who said, "I know more than my grandmother, I know more than my grandfather, but I'm no wiser than they were." So that's how I feel. So, but I'm approaching the question about a united Ireland, however that is configured, as a, and I'm timing myself, as a post-conflict society, and reflecting on the protection of women's rights in that context. And I will allude to the UNSCR 1325. But I am particularly interested in feminist activism and making women's voices heard, or providing spaces for women's voices to be heard, both during and after political conflict on the island of Ireland, on both sides of the current border. And I have been around for quite a while doing that. But I want to begin with reflections on women's rights in Gaza at the present time, at a time of war. And then with examples of activism in this local context, and illustrating how feminist activism has created spaces for women's voices to be heard, ensuring that women's rights are certainly asserted and thus influencing progressive policies in a post-conflict context. So if we talk about women's rights in a time of war in Gaza, obviously they don't have any. That's obviously the case. And following the brutal massacre by Hamas on the 7th of October of innocent Israeli men, women and children, and the taking of hostages, Israel responded by declaring war against Hamas, but the scale of indiscriminate attacks on civilians, the bombing of residential buildings, hospitals, churches and schools, the flattening of neighbourhoods amounts to a war of genocide. And the international reporting sees women and children and old people as innocent victims of the conflict, which they are. The constant threat of violence, loss of loved ones, and the disruption of their daily lives can have lasting effects on women's health and that of their children. However, this view of women as essentially innocent disregards women's agency, and this perception is often associated with stereotypes of women as passive, helpless, and in need of protection during war. While it is important to acknowledge the specific vulnerabilities that women may face during armed conflicts, it is equally important to recognise their agency, resilience, and their active role in dealing with the challenges of war and making their voices heard. So despite their circumstances, women from Gaza have found ways to make their voices heard by us, And the Belfast-based Social Change Initiative, for example, hosted a delegation of Palestinian women leaders in Belfast last June, and that was hosted by Monica McWilliams and Avila Kilmurray. And some of the participants were from Gaza. And these women have sent a statement that is a call to our humanity. So what they write is this, and I quote, "War is one of the most awful phrases and actions humans have ever invented. In these difficult, painful times, women find themselves responsible for finding self-shelters for their family members, thinking of their security and safety, and above all, their mental health. In these difficult times, women usually ignore the necessity of considering self-care in its many different aspects, even when they are traumatized. They try quickly to respond and overcome the immensity of what is happening to them, considering that their priority should always be the family. This huge burden continues even after the immediate war ends, and women still find themselves having to confront the consequences of the violence as it impacts on them in different ways, mentally, physically, economically, and socially." So this statement, they say, is not to argue politics or a call to stand with one side only. It is an argument of humanity. Your voices and calls to stop these disproportionate attacks and war crimes can make a difference. Your actions to pressure world leaders to act to save women and children of Gaza count. Your expressions of concern to protect innocent civilians in Gaza can have an impact. So in this time of war, in terms of women's rights, I can only add my voice to calls for a humanitarian ceasefire. So what happens when the military invasion ends? And it is a grim picture, I think. So I will turn now to the UN Security Council 1325, which was adopted in 2000. And was a landmark resolution at the time that addresses the impact of armed conflict on women and recognizes the role of women in peace building and conflict resolution. I think what is important to say about it is that it was a result of feminist activism through the concerted efforts of various women's organizations and feminists working at local, governmental, and UN level who advocated for the recognition of women's rights in conflict zones. It proposes key elements. I won't go through the whole detail of it, but they are participation, protection, prevention, relief and recovery, and humanitarian assistance. So that resolution and subsequent resolutions have played a significant role in raising the awareness of armed conflict impacts on women and emphasizing the importance of women's participation in conflict prevention, peace negotiations, and post-conflict reconstruction. From a critical feminist perspective, however, the effectiveness of UNSCR 1325 in practice remains limited due to various challenges and shortcomings, including gaps in implementation, tokenism, that gender mainstreaming often masks, and the ongoing marginalization of women's voices. So inevitably, perhaps, 1325 fails to take into account the intersectionality of women's experiences, limited resources and funding required for full implementation. So addressing these issues requires a more comprehensive and intersectional approach that goes beyond the mere adoption of resolutions and focuses instead on genuine empowerment, participation, and protection of women in post-conflict environments. So turning to the local context, to here in the north of Ireland, we have learned how a political conflict can and has been addressed through a peace process, one which women have engaged in at grassroots level, as well as in political parties and uniquely in the Women's Coalition. It is a peace process that is ongoing, and I want here to draw attention to the mostly invisible grassroots feminist projects that have made significant contributions to peace building across the island. The British government, as has also been alluded to, obviously hasn't produced any kind of national action plan around 1325, but the Irish government has developed national action plans and outlining specific strategies and actions to advance the goals of 1325. The first one was in 2011 and the most recent in 2019. But well before that, in the 1980s, there was an upsurge of locally based women's groups who, without calling themselves feminist or developing an agreed feminist or political agenda, set about organising activities for women to combat isolation, poverty and social exclusion. And this is the phenomenon that has become known as the women's community sector. At the end of the 1990s, there were well over 1,000 individual women's groups in the south alone and an estimated 450 groups in the north. These form the women's community sector, with the majority engaged in community education, a radical consciousness-raising education. This was before the whole the neoliberal agenda of doing away with all that and having to do qualifications to get into the employment market. And many had a political and human rights focus. And theirs is a hidden history because they never had the resources to record any of this. They were just so busy trying to survive. However, some did leave a record, and one of the important ones here, I think, in the north is in 1994, is Clonamán, the Women's Agenda. And Clonamán was a Republican feminist group that formed in 1993, and based on a series of informal conversations about the future of women in Irish nationalism, Clonamán officially formed in 1994 in the wake of the ongoing Hume Adams talks. So they sought to bring Republican women together to discuss what a new Northern Irish society might look like. And Clonamán was committed to ensuring that the voices of working class women were heard and made a difference when it came to shaping the future beyond violent conflict. So at the group's first conference in March 1994, entitled Clonamán, Women's Agenda for Peace, there was a shared concern that the new society promised through the peace process would mean business as usual for women. By that they meant that women's socioeconomic and political inequalities would remain intact and invisible. So this quote from the conference report remains inspirational, I think. We want a society which enables women to make choices about their lives and which will enable all women to live lives of dignity. This means the right to economic security and the right to participate fully in public, social and economic and political life without having to overcome barriers of accessibility or lack of childcare. We want the right to a future for our children without the necessity of emigration for economic or social reasons. We need the right to live our lives free from the fear of violence, the right to choose our sexual orientation and to define and choose our family relationships, the right to equal access to services. We need the right to work and the right to economic security, the right to live and make choices free from fear, the right to freedom from fear of homelessness, the right to control our fertility, the right to education and healthcare. So the agenda put forward as a result of the conference called for a demilitarized society, economic equality, rights for children, and an end to discrimination against disabled people and lesbians. These proposals were submitted to the Forum for Peace and Reconciliation. In this way, Clonamán, a small feminist group of activists, helped to shape the equality measures introduced in the Good Friday Agreement. So then, in 1998, we had the Women's Coalition. And the story of the Women's Coalition is also remarkable, if better known. The D'Hondt system, as you will know, introduced to ensure participation from small loyalist paramilitary organisations, making it possible for the Women's Coalition to register as a political party, and run candidates in the 1998 elections that followed the Good Friday Agreement, winning 2 seats in the Northern Ireland Assembly. The coalition relied on the support of numerous local women's groups in Belfast and across the north to get a women's voice elected to the talks. Women's groups felt empowered by the coalition's success, which provided a platform for women to advocate for their rights and to influence policy and legislation. But as we know, the party lost its seats in the Northern Ireland Assembly after the 2003 elections. This, of course, preceded the adoption this preceded the adoption of UNSCR 1325 for, resolutions. So while the Good Friday Agreement marked a significant step toward peace and stability in Northern Ireland, the commitments to equality and rights in the agreement did not have strong implementation mechanisms in the legislation that followed. We continue 25 years later with no Bill of Rights. The most marginalised women's circumstances are unchanged. There has been some progress and some women have become prominent in political parties, but there has been no cross-party commitment to women's equality. Women's groups have faced ongoing challenges in advocating for their rights and addressing issues such as domestic violence, poverty, and community development, and this has included working on cross-border projects. So I've been involved in quite a few of these over the years, and most of them are pretty much lost because they just weren't recorded, and it was before the internet in some ways. So there was one that was called the Power Partnership, which meant politically organised women educating for revolution, or that was changed to representation for the funders, but anyway, which was a cross-border partnership between the Women's Support Network and this university, Ulster University in the north, and the National Women's Council and the UCD, the Women's Education Resource and Research Centre in the south. Oh, that's my 50 minutes. I'll hurry up. Okay. That ran for a couple of years until the funding ran out. And then another one, which was Hannah's House, which was inspired by Hannah Sheehy Skeffington, began in 1999. And one of its key aims was to support dialogue between women and policymakers and politicians that would strengthen the capacity of women to have their interests reflected in future policy developments. Again, the Hannah's House organised seminars and conferences across the island discussing the legacy of the conflict, a feminist analysis of peace building, women's right to security in the home, locally and globally, and what a model of truth recovery processes would look like. And it also held a major conference on UNSCR 1325. So in conclusion, and many of these have just, and that Hannah's House also, its funding ended, and again has been slightly lost to history. But for many years now, cross-border women's activism has been instrumental in promoting women's rights by fostering dialogue, taking an intersectional approach to inequalities, advocating for inclusivity, and addressing gender-specific issues, lobbying government, and engaging with international human rights mechanisms. So a crucial issue, though, is the issue of violence against women, which is a globally endemic. So in the north here, hasn't had a strategy for tackling violence against women, is now being addressed through a consultation launched by the Executive Office, Raise Your Voice, Women's Aid, the WRDA and the Women's Policy Group have all been central to calling for a strategy, relentlessly, according to Elaine, relentless pressure for many years. So in the south, what is interesting by contrast is that the current Minister of Justice, Helen McEntee, has introduced a zero-tolerance strategy that has already resulted in tougher sentences for violence against women, alongside the introduction of non-fatal strangulation and stalking as new and standalone offences, respectively. So the maximum sentence for assault causing harm has doubled, the scope of the existing harassment offence has been widened, and in the cases of non-fatal strangulation or suffocation causing serious harm, there's now a maximum sentence of up to life imprisonment. And that just illustrates how women in positions of power, where they open a window of opportunity to protect women's rights. So it's a reflection of political will to protect women's rights, but it's also a reflection, as in the North, of feminist activism and the successful advocacy of the Irish Observatory on Violence Against Women, which was established in 2002. It's an independent network of grassroots and national organisations that come together quarterly to monitor progress on violence against women in Ireland, linked to the European lobby. And both the Observatory and the Women's Lobby in the North are currently responding to the Council of Europe's report on the Istanbul Convention. So finally, just to say a little bit about the All-Ireland Women's Forum, which is coordinated by the National Women's Council. And it brings together women from both sides of the border, from marginalised communities and spanning generations. As well as centring women's voices in peace building, the Forum has found that more must be done, that it's clear that much more has to be done to build all-Ireland alliances and solidarity. The Forum has made recommendations to both governments, including developing an all-Ireland strategy on gender-based violence, introducing gender quotas for local politics, and a North-South media partnership which would increase women's voices on all-Ireland issues. So currently 2 cross-border initiatives are set to address women's right for freedom from violence and freedom from poverty. So that itself is supported by short-term funding, and there is a strong case to be made for building relationships and supporting solidarity between women's organisations, North and South. Because, finally, in all honesty, the protection of women's rights is going to involve the same challenges as exist here and now on this island and across the world. Thank you.
Thank you very much, Joanne. Building on that, particularly that history of where women's rights are on the island, many other initiatives since the peace agreement, not least one of the first funded by Peace One, making women seen and heard in conjunction with the National Women's Council, my own union, women's organisations in the North, identifying over 400 women's organisations in the 12 counties covered by the peace programme. And I have to say that the conclusion of a year's work with the 400 organisations was endorsed by the Irish government, it was endorsed by the UK government, it was endorsed by the new incoming Northern Ireland government, and all sorts of promises were made as women from both rural and urban areas identified social and economic needs and rights that were unrealised. And to date, the vast majority of those have not been realised. So we know that there's a massive programme of work to be done, and the most recent work, the most stunning work, has been done via WRDA and the other women's organisations, particularly on the post-COVID feminist recovery plan. So I am absolutely delighted to be able to introduce now, right up to date, Elaine Crory, who is the women's sector lobbyist based at WRDA. And she's also currently a special advisor to the Westminster Women and Equalities Committee inquiry on violence against women and girls. And of course, very importantly, she's a member of the Equality Coalition. You're on, Elaine.
Thanks so much, Patricia, and thank you to Róisín, and thanks for having me in general. No thanks at all for putting me last after such fantastic speakers, which means that all of the good zingers have already been taken, but I'll do my best. So we talked earlier about stepping back, and so I decided when I was deciding on what topic I'd write about to step all the way back. And I've called mine, What Do We Mean by Women's Rights? Kind of in the first place. And I've done this mostly because I'm discomforted by the general conversation in public spaces around rights, not spaces like this one, where you've got rooms full of people who know so much about human rights that there's no need to pause and linger over it. But in spaces unlike this one, where the opposite is true. So oftentimes in public conversation, when we're talking about human rights, we tend to think of them as focused around particular issues. So the right to vote, tick, done. The right to have an abortion, tick, done, or sometimes. The right to equal pay, tick, done, on paper anyway. The reality is both at the same time much more complex, of course, because a right written down on paper doesn't mean it's true, but it's also much more simple, because we don't have to go through a pile of rights and go, well, these ones are women's, okay, over there, and these ones are children's over here. They're human rights. So if we have an understanding of human rights, we have an understanding of what women's rights are, because I know that when I was introduced, I have a very strange job title, and some of you will know my job title, and so you won't think about it. But for people who I meet for the first time and tell them my job title, you see a veil of confusion drop over their face, because they're like, what's that? If I had to describe it, it's sitting down with decision makers, as we call them, and explaining to them that you can't silo off certain policy areas and put them in a box and say those are women's concerns. So when we're talking about health and education, maybe sometimes anything related to children, you've got to have a woman in the room. But for everything else, and especially the hard stuff, the economy, finance, which women don't really care anyway. So my job is to go in there and tell them, actually, I'm sorry, but no. They still haven't got it, but we work on it. So there's a chant that we use sometimes in the women's movement, and especially at rallies, which is women's rights are human rights. And that's as simple as that. Really, all human rights are also women's rights. The X factor is not which ones are women's rights and which ones aren't. It's how do you actually realise those rights. And when I talk about human rights, I'm again not talking about, I think you all know this, I'm talking about the UN Charter of Human Rights. I'm not talking about some rights that might be codified in domestic law somewhere, like the right to bear arms, for example, which is not a UN recognised right, of course. But it's sometimes what people are thinking of when they use the word rights. So I'm also not just talking about civil and political rights, also social and economic rights. So things, and cultural rights indeed. So things like the right to adequate food, to adequate housing, to adequate employment. And while these things are unrealised in general, they're particularly unrealised if you happen to be a woman or a minoritised person, or God forbid, a further minoritised woman. So, it's harder and harder and harder to access those rights if you are, for example, a disabled woman, or a migrant woman, or a woman of colour. And that's particularly something that the states don't want to recognise, because it means all sorts of obligations for them that they don't want to live up to. They don't want to look, for example, at benefits levels and go, well, that's violating multiple human rights on, social and economic rights. And when the US Special Rapporteur says that it is violating those rights, they will simply stand in the Parliament and say, no, it's not. Back the Ashes. It doesn't mean anything. It's just a language they can use and deny. And we don't have enough of a robust mechanism for holding them to account. So I'll come back to that in a bit. And also, as has been mentioned before, so I won't belabour it, rights have to be understood intersectionally. So women are much more than just women. They are women who speak Irish, or women who have disabilities, or women who are unionists, or whatever else. So the goal is to realise all of that. So what's the obstacles? Where to start? So the history of both the jurisdictions on this island is extremely poor when it comes to women's rights. So that's whether you understand the jurisdiction that we're in right now to be the post-1998 kind of state, or the United Kingdom, or some combination thereof. And the state in the south understood to be everything after 1922. We have a culture as well, and I say we, not we, but we generally have a culture of kind of finger pointing when it suits, like, oh, we're much more liberal than them, oh, we're doing so much better than that lot, oh, look at how much better we've progressed than them, they're regressing and all that stuff. But we also have a terrible culture of kind of navel-gazing sometimes, that navel-gazing self-pity that says, oh, this is the worst place in the world, why is it that nobody's looking at what the terrible thing that our government is doing, which leads to difficulty in building solidarity and building movements across borders. That has been overcome loads of times, but as Joanna has mentioned, around cross-community kind of work, but also things like the repeal referendum, equal marriage and that kind of stuff. But it tends to be issue-based, and it tends to be short-lived, and oftentimes not well recognised or well resourced so it can't last for very long, unfortunately. And while this is changing in time, and it makes it much easier now, we have the internet and all of the other things we have to keep in touch, and circumstances are helping it change as well, which is that this conversation that we're having right here in this room today is coming to a head, or heading towards in the direction roughly of a head rather than coming to a head just yet. Sometimes there's still a failure to build movements when they could be built, and there are efforts, and Joanna and I are both on the Aoláin Women's Forum, but it needs to be much, much bigger, and I think we'd agree with that. Not that forum necessarily, but the movement building. There's also sometimes a failure of imagination and a failure of optimism. So sometimes when you speak about, what might the future be like, whatever the constitutional arrangement is, it's imagined that simply the territory of the Republic of Ireland would expand and everything else would stay exactly the same. Or nothing would change at all and we would just stay exactly where we are, delighted and happy to be here. And that failure of imagination is what will trip us up, and we'll be complaining about it, or not us, but people like us 30 or 40 years into the future. Why didn't they do better when they had the chance? And I wouldn't blame them. The prospect of a future united Ireland, or a strengthened union, or whatever it is you're having, doesn't by itself present us with any answers. We have to do, if we want actual solutions to human rights issues, we have to do something else. But before we do that, we have to pause over, what do we even understand what women's rights are? And when I said I was stepping back, I wasn't exaggerating, because public conversation on rights, and women's rights in particular, is often very confused. And sometimes that confusion is genuine. Do we even... I don't remember learning an awful lot about rights in school, even though I took the kind of subjects that would have facilitated that, and I knew what I wanted to do at university, and I had an interest. And I certainly don't remember much in terms of public conversation, the kind of thing people talked about over their dinner and so forth. There were often, enlivened conversations about particular issues, but about rights as a concept, is it too woolly for many of us to get? Do we not spend enough time talking about it to understand it fully in the first place? Are we encouraged to know about rights, or is it easier for everyone if we don't? Sometimes, though, the confusion is deliberately manufactured. And right now we're at a time of what I'm politely going to call culture wars. So women's rights are used as a cudgel in the one hand against LGBTQ people, and particularly transgender people. Usually the right they imagine, which is apparently something to do with bathrooms and sports, is totally made up and imaginary, but it's used, the point of it is not whether it's real or not, the point is to put down another minority. And then on the other hand, you also hear women's rights suddenly, and women's safety is suddenly a primary issue for the far right when they want to have a go at migrants, and particularly something called an undocumented man. I've never met a documented man, but that's a different thing. All of this is happening against the background of the government of the day. And in the UK right now, we have a government that's actively hostile to the very idea of human rights. This morning there was a victory, I think, for human rights in the ruling that the policy to deport people to Rwanda was illegal, and that is a good day. But there's a million other things. Not only do they not recognise rights in some of the most flagrant ways possible, but also it's things like the economic and social rights that we talked about. People are starving to death and freezing in cold houses all over the UK right now. And they don't, the government don't particularly recognise that they have a right not to do that, not to have to be put in that position. So it's tempting sometimes to think escaping from the UK is the answer. Because right now, if you look at them both, you might think, well, look, Ireland is doing better on these things than Britain. But caution is enormously advised, because whatever happens next, whatever happens the day after a referendum, human rights will have to be the spine in the metaphorical body of any future constitutional arrangement. I know there was a lot of work done on the idea of a Bill of Rights, and we're supposed to have, again, one of those things of where it's written down doesn't mean it happens, right? We're supposed to have a Bill of Rights in Northern Ireland. We don't. But even if we do, sometimes there's a tendency to see the Bill of Rights as a supplement, an appendix. It has to be the spine of whatever comes next. And there has to be, along with that, mechanisms by which people, citizens, can pull the cord on that spine and prevent the government from doing certain things. Now, we have human rights bodies and we have courts for now anyway, we'll see what happens next over in Britain, that are mechanisms, but they're far too complex for most people, and they're far too expensive and inaccessible for most people, and they really do need robust human rights bodies. And there's an agenda to erode those human rights bodies. So those human rights bodies have to be fully independent and fully insulated from shocks. And by shocks, I'm talking about a hostile government in the future. It could be far, far worse. And just because something looks better now, one state looks better now in comparison with the other, doesn't mean that in 5 years or 10 years or 20 years, the situation won't be reversed. It's been reversed in the past, it can be reversed in the future. So, coming to the end of my time, and I've really stuck to my time, I practiced this last night, protecting women's rights, to me, means building a robust mechanism for human rights in general. And a clear conversation in which what women's rights mean in that, alongside every other type of minoritised person. And I include children, of whom there are lots, and just like there are lots of women, but minoritised by the kind of system in which all of this is happening. All aspects of human rights have to be built into any future constitutional relationship. I'm agnostic as to what that future constitutional relationship will be. If it's a new Ireland, it has to be a genuinely new Ireland. And I noticed, Róisín's gone, but Róisín mentioned earlier, it's not this grafting on of an extra piece of land. It's a new constitutional arrangement entirely, a new way of thinking about, indeed, what Irishness might be. And in the event that that's not what happens, and whether or not, in fact, it does happen, there is a real need for a human rights movement in the United Kingdom. Going back to my theme about solidarity, it would be a terrible shame if we acted as though we were climbing onto the last lifeboat out of a country in which human rights were being degraded. There is a real, genuine concern in the women's sector, I suppose, but also, I'm speaking for myself here too, that there's a degrading of democracy and of human rights in our neighbouring island and the jurisdiction that we are currently in. Whether we remain part of that or not, we should do everything we can, I think, to add extra lifeboats or to support them in the rebuilding of their human rights infrastructure and in the recognition of human rights law, and ideally in a constitutional arrangement that looks very different to the one that they have right now. So I'll stop now. Thank you.
Okay. Thank you very much, Elaine. Rory's just telling me that Fionnuala has had to go, so it's our other three panellists in the room, and want to do the same thing that. Yeah. Yeah. You want to come up and join us here?
I need to leave at 5 sharp.
Yes, everybody needs to leave. Indeed, I do as well, because some of our hospitals are coming out in support action for their colleagues in Gaza tonight, so it's important that I be at that event. Could we go around the room and could we take 2 or 3 questions? And Rory was going to keep us right about anybody who's asking anything online. Yeah. Who wants to go first? Thank you, Ashe.
Thanks very much. I think, Elaine, it was great your contribution coming at the end and speaking about the practicalities and futures that are unpredictable. So I want to thank you for that. But each of you, including Fidelma, and listening to Fidelma, I hope she can hear okay, reminds me as to why we miss her so much.
Fionnuala.
You're getting them.
Fidelma, we miss you too. You're very much present. But so it's a sort of general question too that really arose from Fionnuala's presentation, where she mentioned intersectionality. And I want to pick up on what she said about self-determination and how she drew our attention to women's bodily self-determination and safety, and made a connection between those. But nevertheless, I want to come back to intersectionality and self-determination. And I want to ask Fionnuala in particular, does she see self-determination as also an intersectional concept, that it makes a difference in relation to social class and in relation to ethnicity, be that race or be that politically defined.
Okay, Fionnuala has had to leave us.
Okay.
Right, so I'm going to direct the question to whoever wants to take it. All three of you, very welcome.
I'll start then, if that's all right. Oh, yeah. I'm just going to be very brief then, because I just remembered I have to stand up to say this. I think one of the things about self-determination, and it's one of the most primal things about humanity, really, the right to self-determination. And if we can't do that, then everything else is almost, glitter on a turd, so to speak. And I think that involves our absolute bodily autonomy, which, it absolutely should be understood intersectionally, but it should be understood deeply. I think in public discourse, we are often talking about abortion, but also it's about LGBT rights, and also it's about the right to decide whether or not you want to be a parent. It's also about things like the thing I work on most often on a day-to-day basis is violence against women and girls, and the human rights framework understands violence against women and girls as a violation of bodily autonomy, because that is what it is. And our legal system doesn't. Our legal system is just so poor at that. So I know I haven't really fully answered your question, but I hope I have. I think there's like a million different ways, and that might even be an understatement. I mean, I know people say a million and they don't literally mean a million. There might be more than that ways in which bodily autonomy can intersect with other parts of your life, and it's not always the most obvious. But yes, I think that's the kind of base of it all. Yeah.
Okay, thanks, Elaine. If we haven't got anybody else indicating, I want to ask. We've heard in all of the contributions. I'll come back to Daniel too. We've heard in all of the contributions that really what's required for the protection of women's rights and minority rights in whatever a new and agreed Ireland might look like is a complete and radical rethink on how you get there. And that's always difficult to question when you're presented with that kind of concept. And I think we heard it very clearly from Fionnuala. She's talking about the fact that we need a new template for the engagement of women at all levels in our society, on the whole island, on the issues that she and all of you subsequently identified are absolutely burning issues for women's rights on the current agenda. So what do you think are the first steps in how we might get there, given that we've tried for 25 years post the Good Friday Agreement to realise those promised rights? Who wants to start? Joanna?
Well, I do think that really, unless there's women relentlessly pressurising for change, it won't happen. But I think there are three things that need to happen for women's rights to be protected. Including that, is there has to be political will, and I think that's been shown recently by Helen McEntee, in the South, has created this window of opportunity where she is really pushing for legislation that will significantly address women's rights, freedom from violence. And so I think you need political will, you need progressive policies and political parties that will have progressive policies, which means getting more women into politics and higher representation of not just of women but of feminists, and then women's activism. Those three things.
Thank you, Joanna. Fidelma?
So just to think about what Fionnuala said, I think what Fionnuala said about the terms that we use to talk about unification is probably going to cause me a week of distress thinking through the implications of that statement. So she says that and then she leaves. So thanks, Fionnuala. Thank you, Fionnuala. That's great. Yes, I mean, look, we've seen it in our work, how entwined borders are with bodies. I mean, over and over again. And if you think back, working class women's bodies couldn't move across borders because they couldn't afford it in terms of reproductive rights. And we're seeing how women understand, as they move across borders, internationally displaced people move across borders, and how their sense of security and well-being is very, very different from maybe other women who are seeing other insecurities. So absolutely, Eilish. And I think, now if I can remember what you asked, I think it's really important to bear in mind, Patricia, if there is a border poll, we're 51% of the voting public. So I'll just leave it there.
Come along, Elaine, please.
Thank you, and I'll be really quick again. I agree with everything that has just been said, but I will add to that, there's such a desperate need for public conversation with women in which we communicate the following two things. Number one, you have rights. It might feel sometimes like you don't, like you're trapped, because that's where you've been placed by the state usually, and sometimes by other forces within your community, but you actually do, and we'll give you the skills and the tools to realise those. But secondly, we're looking at a blank sheet of paper. I think sometimes the defensiveness and the caution and the worry about engaging in these kind of conversations comes from a feeling that you're being herded down a particular path, aiming towards a particular outcome in which you'll have very little say, and next thing you know, you've accidentally rubber stamped something that you hate. Neither one of the current states fills me with delight, to put it mildly. And I know as well that a good government can give with one hand and the next government can take back with the other. And I think that you'd really want to be designing the basics from scratch. And if you approach it like a big box of Lego, and like everyone's a toddler, you can actually come up with much more exciting things than if you come and ask them specific questions. And I think that I remember Professor Murray mentioned earlier the loss of the Civic Forum was a great loss, and I agree, but I think we need spaces even broader and bigger and with more people in them, and ideally especially more women.
Thank you very much, Elaine. Right, I have online, which you're going to give us, Rory, and I had Daniel and I had yourself at the back. So can we take all three of those? Yeah.
So the online question is, women are leading the way in the environmental movement in Ireland. Would you recommend using the framing of Mother Earth in a new constitution to enhance a new Ireland, as in Bolivia?
Daniel?
Yeah, thanks. I had a process question about the sort of outcomes thing. I'm just thinking about how, turning to the question of how women's rights would be protected or represented in any constitution. Obviously it wouldn't be the reference in the current constitution, which seems to be a bit of a difficulty with getting rid of still. But what about the issue of, say, incorporating the whole of CEDAW, for example, into a new constitutional arrangement, or other bits of international standards? I'm thinking 1325, I'm thinking the Istanbul Convention, I'm thinking various other things. What about that?
And colleague at the back.
Forgive me, this is probably going to be one of those more comment than question bits that comes at the end of the day, but I suppose I love the energy of we have a blank sheet of paper and a chance to do something new. I suppose the one caution that I throw in is that it isn't a blank sheet of paper. One of the huge advantages of being an academic is to sit in a room full of people who have done such activism for a long time and think, thank goodness I didn't have to do any of that legwork to get us to the point we are in terms of rights protection. But as Professor Dickson said earlier, some of those rights protections for women, for gay people, have been incredibly hard won in this space, and there is no regression or step backward from it. And when we're talking about a day of advantaging certain minority groups or protecting what they espouse to hold dear in the context of reunification, it's that we don't sacrifice women's or gay people's rights in that context. And they're, goodness, I'm going to say what we have, we hold, and I'm going to hear it stick in my throat at this point. But that there is a baseline of protections that we build upon this context that is not completely going to shoot.
Okay, I'm going to go for the final roundup and put you through this again. So,
Mother Earth.
Mother Earth. Do you want to do it from here so it gets recorded?
I don't know about Mother Earth, but there's definitely a growing group of activists who are involved in feminists who are involved in environmental climate justice issues, and hugely energetic and bringing with them new ideas, very imaginative and very pragmatic, and I think they have a huge amount to contribute. But I don't know about Mother Earth in the Constitution. Don't know.
Fidelma, do you want to pick up on all of them if you can?
All of them, okay. No, not Mother Earth as a model, no. I think we've had Mother Ireland for a model for a while, so maybe we should step away from that kind of imagery into something a bit different. But that's just me. I think we need lots of different visions, and Mother Earth as a vision is as good as any other vision that we can look at and take what we can from it. Now I forgot what the other commentators asked. Daniel, yes, there is a set of prescriptive protections that come directly from CEDAW that they recommend you can put into a constitution. But I think one of the issues is you can't kind of let the constitution just become like a piece of paper. So do you understand me? Because we have that already in international law, where Fionnuala and what Joanna said, what is the women's peace and security agenda? I mean, we've heard about it for years. There's been umpteen books written on it and all the rest of it. And where is it at the minute? So we don't want to have a sort of, global sort of constitution that is the forefront of building gender equality, really, if it's not underpinned by the right sort of value system to make it alive and to make it active. So that would be the only thing I would say there. Colin, I can't remember what you said, but it was about, it's only because it's getting late, and I have so little stamina these days. So, yeah, we have the foundations there. There can be absolutely no backtracking at all, but there's a huge amount of work to be done, particularly on socioeconomic issues of participation and representation. There is a huge amount of work to be done. And as I say, if a space opens, we're not going to have utopia. We're absolutely not. But as feminists, we'll make the best we can of that space, and that's really what we do.
Okay, you're going to tell us how to open the space?
1 minute and 3 answers, right? So first of all, I agree completely with what Fidelma just said in terms of incorporating that stuff into the Constitution, all those pieces of legislation like CEDAW, like the Istanbul Convention. Yes, but also that's not enough. I think it needs more than that. It needs teeth, and it needs more than, it's already there in international law in most of the states. Like the UK has signed up to those conventions, but they had to be dragged kicking and screaming to abortion rights through CEDAW, and it was kicking and screaming all the way. So it needs more. It needs more than that. The other thing about Mother Earth, with my work hat off and my personal hat on, I feel really strongly about climate change and about what we are doing to this planet. I'm reluctant to use language around motherhood and maternity because I think that can equally be used and is often used to oppress women too. But I do like the concept of the rights of nature, and there is a movement around that. So if you Google rights of nature, you can find out all about them. To enshrine the rights of nature, like living things on this earth that are not human or animal, but also animals, into actual law. Which means that, for example, you can't just go around chopping down trees. I'm looking at you, Department for Infrastructure. And then last thing was what you said there about like a blank slate, but yeah, you don't want to roll back on anything. And I totally agree. To me, with human rights as the sort of spine of this thing, it means you can't do away with any rights that have already been won, but also you can't pick and choose which rights in general you want to enshrine. They all have to be there, whether the ones that were previously like won in like you say, hard-fought battles, or ones that really haven't been litigated yet, or ones that are theoretically in domestic law and not actually enacted at all. So I see that as the paper, if you will. To use that analogy of the blank sheet of paper, that is the paper. You can write on top of the paper, but you can't not have the paper. That analogy I stretched way too far. I'm sorry, but I hope it makes sense.
Well, thank you all, and a big thank you to all our panel members. Anybody else closing? Anybody else wishes to close? No, I just leave it to the woman, for God's sake. Okay. Oh, yes, I want you to say a few things. Thank you very much, Rory. Thought I was being left in the lurch there. Please come along.
Not at all, not at all. Yes, well, let me just say thank you again to everyone who has chaired today, who has spoken today. It was, I think, incredibly rich, full of lots of details, lots of insights, lots of challenges. So many things for us to think about going forward. So thank you to all of you. Thank you to all of my colleagues at Ulster who helped make this possible. A special thank you to my indispensable colleague, Alison Gordon, who's been supporting on the Minister's side. It's been a pleasure to do this work with the Equality Coalition. And I particularly have appreciated working with Daniel and Robin in putting together this small mini-series on human rights issues on the island of Ireland. And I think we'll have to go away and think about how we better capture the learning from our seminars and how we disseminate that and how we continue these important conversations going forward. And I suppose I would also just like to, since some points have been referenced during the day, I'm going to take advantage of speaking on behalf of TJI to highlight a couple of things that we have been involved with recently. Well, one thing that we have planned, and a statement also relevant to some of the issues mentioned today. So we have had several mentions of Gaza. As you might imagine, we are trying to put together an event looking at what is happening in Israel-Palestine and Gaza. So we are working on a webinar for the 7th of December as part of Human Rights Week. And for that, we have confirmed speakers Dr. Susan Power from Al-Haq, which is a Palestinian human rights organization, and Professor Bill Shabas, who is a world-leading expert on genocide and international criminal law and international humanitarian law. And we will look at some of the key questions of international law raised by the conflict in Gaza. So including, as one of our PhD researchers put it to me the other day, reflecting on Gaza, does international law actually matter? So these are some of the things we will discuss in that webinar, so please do keep an eye out for us. And then I also just highlight a statement issued just today by the Irish section of Scholars at Risk, which is, as the name suggests, an organisation concerned with protecting scholars internationally who are threatened. And the Irish section has issued today a statement on certain threats to members of academic communities that have become very apparent arising out of the conflict at the moment, including physical attacks, direct violence against students, staff, higher education institutions, concerns about attack on academic freedom and freedom of expression, and concerns about rise in all forms of hatred, including anti-Semitism and Islamophobia. So we will be publicising that statement more widely in the coming days and sharing it with the universities on the island of Ireland as well. So just to highlight those two topics, since they have sort of been referenced slightly, well, more than slightly and quite rightly during the course of the seminar this afternoon. Thank you all for coming along. It's been a fantastic afternoon. Really delighted to have welcomed you to Ulster University, and I hope to see many of you back on our campus again in the near future. Thank you.